Yes, kindly administer the oath. Very well. Yes, we administer the oath.
I, Kissi Agyebeng,
solemnly swear that the evidence I shall give before this committee
solemnly swear that the evidence I shall give before this committee
touching the matter in issue shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Mr. William Kissi Agyebeng, on behalf of the committee, I congratulate you on your nomination to the very unenviable position of Special Prosecutor, the second since the office was instituted. Now we have your CV, but kindly tell us a little more about yourself, those that are relevant to your training, your experience, for the record.
Thank you, Honorable Chair. Good morning, Honorable members. Honorable Chair, I used to be called William, but I dropped it officially a while ago. So my name just remains Kissi Agyebeng.
Well, I've seen that William is on relevant certificates.
Yes.
And so it's important for our record.
Yes, I designated it on my CV as former name. So I'm Kissi Agyebeng. I was born on the 2nd of July, 1978. I started my primary education at Holy Star Academy at Laboni in Accra. And then we moved from La to Teshi, and I was enrolled at the Wajel Barracks School to continue with my primary education. And this is at the military barracks at Teshi Camp. So in 1989, together with a few of my colleagues, we tried our hands at the common entrance examination. And I enrolled at Damfa LA Middle Mixed School because at that time I was a bit too young to write a common entrance. But on the first try, I passed and I gained admission to Accra Academy, where I did my secondary education. I spent 7 years in Accra Academy, Form 1 to Upper 6. I took my GCE O-level in 94 and GCE A-level in 1996. From there, we waited 2 years to enter the university. But in the interim, I did my first national service at the Information Services Department at Asaman Kese. In 1998, I gained admission to read law at the University of Ghana, where I graduated in 2001 with a Bachelor of Laws LLB degree, first class honors. And then I proceeded to the Ghana School of Law in 2001. I was called to the bar on 3rd October 2003 after having successfully completed the professional law course. And then I returned to the university as a teaching assistant in the law of contract and conflict of laws before my pupillage. And my pupillage at Zoe Achia & Co. between 2003 and 2004. I gained admission to read a Master of Laws program in Marine and Environmental Studies at the Schulich School of Law at Dalhousie University in Halifax, Nova Scotia, Canada in 2004. I graduated in 2005, and then I also proceeded to read another Master of Laws program, LLM, at the Cornell Law School in Ithaca, New York, in the United States. I then returned home, and I was appointed a lecturer in 2006 at the University of Ghana, Faculty of Law, now School of Law, where I've been teaching the past 15 years to date. Alongside that, I was also building my private practice. I had a few stints at the Center for Public Interest Law, a human rights public interest law firm. I had another stint at the Legal Resources Center, another human rights law firm. And then around about in 2008, 2009, I joined a new law firm that was being formed, Aina and Feli. I was there till 2013. And in 2014, I formed my own law firm with a partner, Cromwell Gray LLP. And I've remained the managing partner to date. I was appointed as the chairman of the Electronic Communications Tribunal in 2019, and I've been the chair till date. Mr. Chairman, Honorable Chairman, in sum, these are the highlights of Kissi Agyebeng.
Let me ask you before I continue. All this while that you were moving from one chamber to another, forming your own chambers, you are still an employee of the...
When our forebears argued successfully that the law court is the laboratory of the lawyer. So the theories we propound in the law classroom should be tested out there for its veracity. So we are allowed to practice and still lecture at the same time.
You mean it's the university policy that a lecturer at the law faculty can also engage in private legal practice? I just want those things for
Yes, Honorable Chair.
Chairman, I should thank you for the opportunity and should join you in congratulating Kissi Agyebeng, Kissi Agyebeng, Kissi Roland, Kissi William. Chairman, I'm doing it on purpose. I'll soon be asking him after my opening remarks when he dropped the formal or informal name of William for our record. But Chairman, this just to warm him to, as you describe it, the unenviable position, high office of Special Prosecutor. Ghana needs you. And Ghana will need a person who would fearlessly and courageously fight corruption, to which we are told we lose $3 billion annually to graft and economic-related crimes and to fraudulent practices associated with procurement and other unethical conduct in our country. Moral crusades have not helped us. High ethical standards have not helped us. We need persons or a person with a will to support the president and the country to nip corruption, because it has shattered the dreams of many, contributed to joblessness in our country and to poverty in our country. So welcome. But Chairman, when did you drop the William and why?
Formally earlier this year.
So it's just a 2020 drop, a 2021 drop.
It had become redundant for more than 30 years.
But not abandoned informally.
Yes.
Some of your friends.
So I decided to formally drop it.
All right. So, Chairman, to now Kissi Agyebeng, why did you have to drop William?
Honorable Chair, I've just explained that it had become redundant.
What made it redundant? Was that a baptism name?
It was a baptism
name.
You
didn't name yourself. You know that, culturally
no,
and religiously.
Actually, Honorable Chair, I would have dropped it long ago, but because my father was also called William. So it was an honor to him that I was still keeping it. But after I made my peace with him...
So was it in dishonor to drop it?
No, Honorable Chair. I made my peace with him that I needed to check that foreign name from my name and keep my local names.
All right. So, Chairman, just to, I'm happy to state that you used to teach conflict of the laws and law of contract. Now, you know the evidential rule, burden of proof, particularly in criminal jurisprudence, proof beyond reasonable doubt. Do you share the view that we should criminalize unexplained wealth in Ghana? Do you share the view that we should criminalize unexplained wealth in Ghana?
It is a bit too, Honorable Chair, it is a bit too overbroad to state unexplained wealth. In criminal jurisprudence, criminal constructs should be more pointed, more focused, and clearly delineated because of the specter of someone ending up in jail, losing his liberty, or being fined heftily for an amount. And so if we are to place it in proper context, unexplained wealth, I would say that if the person cannot reasonably explain as matched against his lawful income the amount of money in question, then that aspect, in my opinion, should be criminalized. But if you can reasonably explain how you came about that amount of money, then that should be allowable, that should be acceptable. So in your context, unexplained wealth would be reasonable explanation of the source of that property, wealth, or funds.
Chairman, just to take the nominee, I appreciate your response to it. If you take the United Kingdom today, where Ghana largely borrowed its legal system, largely, they now, for purposes of combating economic crime and fighting corruption, have what they call a reverse burden of proof, that the onus must shift, that when those assets cannot be explained for, an irrebuttable presumption is that they are acquired illegally, fraudulently. It may be taking advantage of the state and its resources. So they now go for a reverse burden of proof. Will you subscribe to that for Ghana in our quest, our collective quest to fight corruption? Thank you, Chair.
Honorable Chair, I'll link it to my answer to the first question. Also pointing out that criminal constructs are very, very dangerous if not well thought out. A reverse onus clause, as the honorable member rightly put it, puts the burden on the accused person to explain to explain one way or the other the charge against him, rather than the prosecution bearing the burden of proving his guilt. In the context in which I answered the first question, of course, if the construct here is that you cannot reasonably explain as to how you came by that wealth or property matched against your lawful income, then it presupposes that I have already placed the onus on you to show as to how you came lawfully in possession of that wealth, property, or funds. So in that context, my answer will be yes.
So, Chairman, still there, you have like a public official, maybe a public procurement authority, who has 9 million in his account. And for purposes of accountability, that's why every country that is committed to fighting corruption has asset declaration regimes. And the essence is that you should be able to match incomes, legitimate and lawful, with unexplained wealth. Now you have this 9 million in the account of a public official, and maybe 3-4 years back, that money was not there. It's probably because he's associated with the political authority in power, and his income cannot explain a 9 million in his account. If you were a special prosecutor and that was brought to your attention by an ombudsman in the Republic, what would be your attitude to dealing with this matter? Thank you, Chair.
Honorable Chair, as I stated, it should be matched against your lawful income. And so I'll be looking at, in respect of the sources of that income. Perhaps the person in question earns some other income from some other vocation. Maybe he has a cocoa farm somewhere, in a forest area somewhere, and he earns money from it. That would be lawful. So whatever the source of the income is should be lawful. So the aggregate...
So accepted, Chairman, accepted. So now, is it not the case that the state could say, okay, come and explain to us in the context of the British system how you got this 9 million? That's the reverse burden of proof. The proof beyond reasonable doubt is no longer going to be the onus on the state. But we cannot explain how come you have 9-10 million as public official in your account. And legitimately, there's nobody in Ghana from the president through ministers of state, except those undertaking businesses, who should have that quantum of money. You are to help us fight corruption. Wealth that cannot be explained. We want you to be the lead police in tracking and finding answers to them to save this republic. Can I have your commitment to that? Thank you, Chair.
Honorable Chair, you have my firm commitment. You know, Honorable Chair, corruption is secretive and very, very complex. And most of the time, it transcends national boundaries. And unless the participants of the corrupt activity are opening up to you, it is very, very difficult to, on your own, establish that these funds came about unlawfully. And so, as I keep saying, if I were to place the burden on you, matched against your lawful income, and you cannot reasonably explain the shortfall as to how your lawful income falls short of your wealth, then I'll be asking you questions. Then I'll be calling you in.
Will you ask those questions as special prosecutor? How prepared are you to fall into the heavy shoes of Martin Amidu, given his enormous experience in the background? Many have referred to your age so far. Reading your CV, I'm encouraged that if you would be fair, firm, and courageous, we'll get somewhere. Now, it's indicated that the most veritable source of corruption globally, and particularly Ghana, is the abuse of conflict of interest. And many situations of unethical behavior is associated with persons' conflict of interest. What strategy do you have? People want to reward family and friends, want to reward other persons. Sometimes corporate entities that are formed overnight will win contracts and bid against very experienced hands in the name of conflict of interest and its abuse. What will you do as special prosecutor to give respect to the provisions of the Constitution on conflict of interest and barring public office holders from abusing that opportunity? Thank you, Chair.
Honorable Chair, there was a reference to heavy shoes of a named individual. Honorable Chair, I'd like to state that I prefer to wear my own shoes, in the sense that I am my own man and I'm coming with my own experiences and professional training. In this quest, my conscience and my learning of the law are going to be my guide. My strategy is that, Honorable Chair, I'm not naive to assume that I'm coming to stop corruption. There is no way I can stop corruption. God himself will not even acclaim to that. But I am going to make corruption very costly, very, very costly to engage in terms of conflict of interest.
Chairman, he has just said that he'll make corruption costly, high-risk activity. How do you intend to walk that road?
Exactly.
Thank you.
Honorable Chair, first, I'm going to institute what I call pressure for progress. And in this quest, there will be a systemic review of all public agencies.
What was the word you...
I said I have termed it pressure for progress.
Pressure for progress.
Yes.
Very well. I thought it was a Latin word you spoke. I didn't get it out.
I'm going to institute systemic reviews of public sector institutions and the development of integrity plans. And here, this is what I intend to do. Why can't we have our own corruption perceptions index, for instance? Why can't I rank public sector agencies against each other? And at the end of the year, publicize the results as to which institution is performing well and which institution is not performing well. In that quest, if you are head of an institution and persistently your institution is drawing the short straw in terms of the perception of corruption from the point of view of experts, from the point of view of business people, you will set up. Because
Special Prosecutor, you're aware that you are being appointed to operate a particular law. Where will you draw your authority to be publishing perception, corruption, or corruption perception index of agencies? Where under the law will you have that your authority from?
Which, The Act empowers me, if I'm given the nod by this House, to institutionalize risk assessment in respect of public agencies. And in doing risk assessment, in terms of the activities of public sector agencies, it is a form of institutionalization of that systemic review of their activities. The Act also empowers me periodically, if I'm given the nod, to publish the activities of the OSP and the operations engaged in. In line with this, it is an offshoot of the mandate of the OSP that I could go ahead after the process of risk assessment, integrity of every public sector agency, to then come out with my results as to who is doing well and who is not doing well. It is an offshoot of that mandate.
Are you done
may I
with
proceed?
answering
No,
his question?
I'm not done.
Continue with that one, and other members will come in.
From the Act, Honorable Chair, 4 divisions have been created therein: finance and administration, prosecutions, investigations, asset recovery, and management. I intend to create 2 more divisions to give more teeth to the OSP office if given the nod. The Act itself envisages that the OSP can create more divisions if it so desires. And I'll be adding 2 divisions. One, a strategy and research division.
Chairman, just hold it there. I'm not interjecting. Go to section 19 of your Act and make appropriate references for our purposes. You are just special prosecutor. The law assumes that you have a board. And in answering the question as chairman posed it, the mandate is not just yours. So reference the board for our purposes, for our record. You only can create additional divisions with the concurrence of the board. Is that not legally accurate? Am I not accurate?
It is so, Honorable Chair. I believe, my apologies, but I believe I said the OSP. So when I said the OSP, it wasn't in reference to a person, but the office. So the aggregate of the office, including the board. That is the context in which I placed it. Yes. May I proceed?
Very well. Yes. Honorable Gaga.
Mr. Kissi Agyebeng, congratulations. Honorable Chair, just to place on record that the Honorable nominee actually handed over to me as legal secretary. If you go through his CV, and so I'd like to congratulate him. But having said that,
Being a consideration of the OSP, would you consider yourself in a conflict situation?
not at all, Honorable Chairman. not at all. Yes, but it's important to make that disclosure. Yes. Yes, having said that, Mr. Agyebeng, when you were nominated as a special prosecutor by the Attorney General, I chanced upon an article written by a man who would be your predecessor if this committee gives you the nod. And in that article, you have been described in language that is not too palatable by the said former special prosecutor. Now, in it, he says that Mr. Kissi Agyebeng is a surrogate of a law firm. Then he goes on to further implicate you as one of the key architects of the botched Ejapa royalties transaction. Now, if you juxtapose these allegations with the role of special prosecutor as an entity that ought to be independent, you have your would-be predecessor, that is, if given the nod, describe you in such language. Honorable nominee, what is your take on this? Are you a surrogate of anybody?
Honorable Chair, I think before I go on, there's one more disclosure that I have to make in respect of Honorable Member Busa North. I was actually the chairman at his wedding reception.
Chairman was right. That he almost said that, yes, I do on your lips too.
Honorable Chair, if I may answer. Whoever says I'm a surrogate of a law firm or implicates me in the Ejapa transaction clearly does not know me. Because if you know me, you wouldn't make such allegations. And so all these things that came up, I took it as coming from uninformed positions. Because I was not involved in the Ejapa transaction in any form or manner, by any stretch of the imagination, however fertile. As for relationships, as I just disclosed, the fact that I was so close to you at some point in our lives will not give you, or you not give me a free pass because of that relationship. And that is why I'm here. And if there is a matter, I'm not going to say because I know one person or the other, I'm going to give the person a free pass. I certainly will investigate. But the truth of the matter ought to be told. I wasn't involved in the deal. I was nowhere near it. Indeed, until it started coming up, I didn't even know what it was. For the record, that is the truth. And so I'm no one surrogate. As I said earlier, I'm my own man, and I prefer to wear my own shoes. If the law firm was named, it would have even been fair to me. But if you say I'm a surrogate of a law firm, clearly you don't know me. I run my own law firm. I've been running it since 2014 as a managing partner. I cannot be described as a surrogate of that law firm or any other law firm. Honorable Chair, that's my response.
You have also been described as a very young and inexperienced lawyer who is not fit for purpose. For, these are descriptions that, honorable nominee, what is your reaction to this? That you are too young and naive to be appointed to occupy a position such as the office of Special Prosecutor. Are you, let me ask you this, are you experienced enough to occupy the position of Special Prosecutor?
Honorable Chair, first, the age. I turned 43 years on 2nd July, a few weeks ago. I qualified to be the president of this republic. I am age mates with the president of the French Republic. Indeed, he should forgive me for saying this. I'm a year older than the Minister for Justice and Attorney General. We were mates at the University of Ghana and Ghana School of Law. He is the Minister for Justice and Attorney General. There's no question about his age. Why then throw issues about my age? In terms of experience, as I stated much earlier, I was called to the bar some 18 years ago. I qualified to sit on the Supreme Court of Ghana. Indeed, I'm 3 years past the qualification for Supreme Court. I have taught criminal law, especially in the University of Ghana, for 15 years, continuously. I see, if I'm not mistaken, some of my former students around this table. Honorable member for Ejuso is my former student. Honorable member for Medina is my former student. Honorable member for Kaikwe Central, I was their TA in conflict of laws. These are the products of my experience. They are here, right here, for everyone to see. And, Honorable Chair, to anchor on that, I have had a front row, although I have not been a prosecutor, properly so-called. I have had a front row to landmark prosecutions in this country. As defense counsel, I have been engaged in some very landmark cases, including the Tagore case, the Baglas Kanko case. I conducted them. Honorable Chair, when Tiger IPI and Arumia announced come up with their investigative pieces, I am the one who supervises, and I've been doing this for quite a while, supervises the collation of evidence and all that for presentation to the Attorney General. Without me, the Attorney General's office will be poorer in terms of those prosecutions. So I can go on and on, but my experience is out there. And going beyond this committee to the bigger house, I think the honorable member for Old Tafu was also my former student. My experience is out there. It's on record.
Yeah, honorable nominee, the Office of Special Prosecutor derives its mandate directly from Article 88 of the Constitution. And that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the Special Prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So what the draftsman did in Act 959 is a sort of taking that discretion under Article 88.4 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that will not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses. There is a problematic one, the last one, which says existent offenses in relation to corruption and corruption-related offenses. It's problematic because if it is not well thought through, then a lot of friction could arise there. The reason is simple. There are two main forms of offenses that may arise in this regard. One, we have what we call predicate offenses. With predicate offenses, these are offenses which forms component parts of a bigger offense. And so if the OSP is prosecuting an offense, but its component is not clearly delineated in the Act, in Act 959, and it is in the province of the Attorney General, some friction may arise there. And then the other form of offenses I would refer to as antecedent offenses. Let me give an example of the first one, the predicate offenses. For instance, corruption as an offense could have a predicate offense like money laundering. But money laundering is not specifically stated in Act 959. So the OSP can then go to the umbrella and say, okay, these are existent offenses that arise or are consequent upon corruption. There, the Attorney General could also say, look, money laundering is my province and not yours. That is what I mean. Then in respect of the antecedent offenses, these are offenses that are committed before a major offense itself is committed. For instance, if we take the offense of dishonest receiving under 29, something must have occurred before someone receives or disposes of property. That is to say, if you are dishonestly receiving, you are dishonestly receiving property that is the proceeds of a crime. It means a crime must have already been committed in respect of that property or funds for which you dishonestly receive. If the antecedent offense has not been committed, you do not come in charging someone with dishonestly receiving. And in respect of the antecedent offenses, problems of friction could also arise in respect of the Attorney General. But I see the draftsman also tried to do something under Act 959. He said, the OSP, 30 days, within 30 days after the end of a proceedings, should inform the Attorney General as to the case, its outcome, and all. But I think this can be solved by properly defining, in my opinion, the jurisdiction of the OSP. And here, I would advocate that we should start thinking about, Honorable Chair, if I'm not being overbearing, the passage of a Corrupt Practices Act, which will capture all these things, spell them out properly, define them properly, and the roles will become clearer. Because I'm foreseeing that in the future, serious friction may arise in respect of these umbrella offenses if the thought process is not clearly deliberated on. That's my response, Honorable Chair.
Yes, John Buma. Now, students.
Thank you very much.
Their lecture questions.
Yes, thank you very much, Mr. Chairman, and let me take the privileged opportunity to congratulate my lecturer. Mr. Kissi Agyebeng was one of the favorite lecturers on campus for us as law students, and I want to congratulate you for the nomination. Those of us who know you believe in your competence and what you can deliver for this country. So just rest assured that you have our backing. I have a few questions to ask you, though. Well, this one is now fulfilling my duty as a member of parliament. So, as a defense lawyer, I mean, you have taught us criminal law. We know your inclination to defense. And you have practiced as a defense lawyer for quite a long time. And I'm happy you referred to some of the famous cases that you've been part. How well are you positioning yourself to now transition to be a prosecutor? Since if you look at your track record, your first inclination is to now look at the defenses possible in the act. Now you're supposed to be the prosecutor. How well are you now going to transition yourself to go after the actions rather than defending it?
Honorable Chair, let me take a little swipe at the honorable member. If you remember in tutorials, I always said, be neutral, be in the middle as an arbiter. And that is how I've conducted myself all this while. Of course, when I take my defense cap and I wear it, I'm coming all out to defend my client. But then, I have switched sides so many times, as I alluded to the fact that, for instance, in the announced cases, I'm not on the defense side ever. I'm always on the prosecutorial side because I have to give the primary information to the Attorney General's office to run with it. It's like a baton. So I have had experience with that already. And because of the way I've always conducted myself in these things, it will be second nature to me in that regard. It is not new. It won't be new. And I'm ably placed to do that.
Great. Mr. Chairman, if you look at the Act 959, the act from which your powers have been defined, and if you check from Section 28, where it talks about the powers of your office, up to Section 46, it appears the same, almost the same provisions are provided in the Act 804, which is for the Economic Organized Crime Office Act 804. You are given the powers of seizure, the powers of search, the powers to freeze accounts on suspicion of corruption, among even powers of confiscation to aid your investigations. And you even have 7 days where you can seize property or power before you go to court for confirmation of your orders. All these are also provisions in the Act 804. One of the nightmares of any lawyer, a practicing lawyer in Ghana, is where you are in court with, say, Yoko, and then BNI, which is now NIB, will be waiting to pick your client on the same matter. And it appears this is exactly what we are repeating also with your role. So a lawyer's client can be invited by Yoko on accounts of corruption or tainted funds or accusations of money laundering. And even similar provisions is also found in the Financial Intelligence Act. So FIC could also invite your client. On the same provisions, the Office of Special Prosecutor is also mandated by this act to call your client. What will be your advice as a special prosecutor in instances where your powers as defined in the act conflict with the same provisions in other acts as I've referred to?
Honorable Chair, the advice has come by way of statutory provisions in the act itself. Because Act 959, in Act 959, Parliament says there in the act that we should cooperate. Otherwise, it will be totally duplicitous and unfair to suspects. I think the reason why the other agencies act the way they do is because they don't have the final push of prosecutorial powers, because they would have to refer their dockets to the Attorney General's department. But in this case, everything terminates with the OSP. And so, in that sense, it is a bit different and unique from the other agencies like the FIC, Yoko, BIN, NIB, and Anshraj, for instance. Yes. Since the Act itself is telling all these agencies to cooperate, that is how we need to go. Otherwise, one agency is doing something, another is also doing it. If we don't cooperate, for instance, suspects can easily walk through any crevices we will provide. They will gladly walk through because we are not cooperating, we are not comparing notes. If we cooperate and compare notes, then one agency can see its way clear to say, this falls directly within my province, and I should take it up. And the other agencies would have to let go.
Mr. Chairman, there is a raging legal debate in jurisprudence on law of evidence, on admissibility. Two schools of thought. One school says that evidence is evidence. It doesn't matter how you procured it, even if you stole it. It must be admissible. And in fact, in Ghana, some people refer to it as the Anas principle, where it does not matter even if you were deliberately set up to commit a crime. It is okay. That's one school of thought. Another school of thought questions the legality and the process of procuring such evidence and describe it sometimes as a blackmail or unconstitutional on the rights of the accused persons. These scenarios exist in different countries. In America, for instance, they don't accept the first scenario in cases of Mapp versus Ohio. In India, several lines of cases reject illegally acquired evidence. But when you come to our jurisdiction, and most of the Commonwealth common law jurisdictions, our laws are not clearly defined on whether illegally acquired evidence must be admissible in our courts. As our special prosecutor, and especially with your background in your private practice, with more associated with the Anas principle, in a democratic environment as we have in Ghana, now that you are going to be the Office of Special Prosecutor, how are you going to marry these two schools of thought to ensure that constitutional rights of even accused persons are respected and fairness prevail even in such circumstances?
Honorable Chair, foremost, the Anas principle is not akin to illegally acquiring evidence. It's a different matter. But since time immemorial, Honorable Chair, I agree with the Honorable Member, this debate has been raging. But in recent times, I do believe that our Supreme Court has sought to bring some harmony in respect of these two competing theories that are fighting for mastery. And it has placed it in a more clear contest in terms of what will be acceptable and not what will not be acceptable. So the general rule will then be that, from my reading of all these decisions, the general rule will then be that, and that is how I'm going to go anyway, that if I'm giving the nod, that ordinarily, that's the general, ordinarily, evidence illegally procured will not go in. But then there are accepting circumstances. It depends on the exigency of the matter and the seriousness of the occasion. For instance, if we were to see someone committing blue murder right in front of our eyes, and we videoed him, like what happened with the infamous George Floyd case, are we going to say when the video was being taken of those officers because it wasn't with their consent, the court should not accept the evidence because their privacy was being breached? In that situation, a life was being taken, and it trumps the person's right to privacy, the person who is committing the crime. It trumps his right to privacy. So all said and done, we situate it in the context of a balance. How do you weigh it? That is how we're going to go. How do you weigh it? And if the evidence trumps the right of the perpetrator, it should be accepted.
Well, Mr. Chairman, just a follow-up question.
No, you're done. Yes, Honorable.
Thank you very much. Mr. Kissi, on your nomination, let me congratulate you. In your earlier responses, you touched on the relationship between the Attorney General's office and the Office of the Special Prosecutor. I see in the enactment of Act 959 that we tried to provide some sort of veiled amendment of Article 88 of the Constitution, using specifically 88.4, that says that all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So I assume that the amendment or the passage of this act is hiding under the phrase in accordance with any law. But can you, given your experience as a criminal law lecturer, and I believe being a law lecturer, you do remember your constitutional law also. Can you tell me what you think about Article 88.3 itself? 88.3 itself, which says that the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offences. Is that the clause that we ought to have been amending?
Honorable Chair, as I stated earlier, it is clearly problematic constitutionally. And as I said, some of us expressed our views informally to the then Attorney General as to the constitutionality of the creation of the OSP. And Article 83, as you have identified, is the mother of this problem. And what Parliament has done is it tries to then marry with these provisions in Act 959. It tries to marry in a sort of sidewind fashion 88.3 and 88.4 by just giving the authority of the Attorney General, whether he likes it or not in that sense, if I may be obtuse, to the OSP. So to prevent this situation where the OSP will then be always going to the Attorney General to seek his or her authority to initiate and conduct proceedings. And that is why I said that it appears then when the draftsman saw the mischief, that he hadn't really solved the mischief. He then at the back said, okay, when you finish, tell the Attorney General what you have done. There's still more work to be done. There's still more work to be done on this.
Work to be done by who? Parliament or you?
Honorable Chair, it has to be Parliament with my input and help when I'm giving the nod that we need to clean house properly to make things clearer. As I kept saying earlier, that friction may arise one day. Friction may arise one day if, for instance, a sitting Attorney General and sitting OSP do not see eye to eye really on a certain matter. Serious problems may arise. Honorable Chair, I agree with you. It should have been, if they may forgive me, better thought through. But with what we have, it is food that is still edible. Maybe we can garnish it later, but we can still eat what we have now.
Chairman, which food? This one with salt or without salt?
Now, which have been a Kwama, and it can only be fufu and cracker.
Chairman, if the Honorable Ayarga will accommodate me, so lecturer, conflict of laws. What conflict have you seen between a constitutional provision and an act of parliament? Where should the hierarchy of respect be, in your view? And what should we do the way forward? I like your thinking on this matter, but go further. What should we be doing in order to realign the provisions of the Office of the Special Prosecutor Act consistent with Article 88 of the 1992 Constitution? Thank you, Chair.
Honorable Chair, of course, every law student knows that the Constitution takes precedence. But what should we do? I think I've intimated to it. The mother problem is 88.3. That is where the issues appears to be. And so if we are able to amend 88 in such a way as to lessen its mandatory language in that context, to allow other agencies to perform such a function, because in practice, I would like to believe from my experience that Attorney General's office is already inundated. And so these satellite agencies will need to augment.
Chairman, just a little clarity. So are you for a constitutional amendment to Article 88, or to quote your words, cleaning up the OSP Act? Where do you stand? Are you advocating for review and amendment of Article 88 or specific to the Act? Thank you, Chair.
Honorable Chair, I'm not just limiting my sights to the OSP. I was also transferring it to other agencies, like the FIC, the IOCO and all that. So all these acts, together with Article 88, must be thought out again and clean house.
Yeah, okay. So related to that and the federal house cleaning exercise that we may need to do, from your reading of the Constitution and then Act 959, do you foresee a situation where one will say that the mandate that is given to the special prosecutor is actually not exclusive, and that any time the Attorney General's office can take on any case that has to do with corruption, and also, parallel to whatever the Office of Special Prosecutor is doing, also prosecute those cases, and that we haven't really given an exclusive mandate to the Special Prosecutor?
Honorable Chair, the attempt was made, but the job wasn't finished. And it's because, once again, you had the problem of Article 88.3. It was difficult to go around Article 88.3 to exclude the Attorney General from it. And I would say Attorney General shouldn't be excluded from any criminal proceeding in that sense. Because of the way Article 88 has been couched, it was impossible then in 959, when the mandate of the OSP was being spelled out, to then say that the OSP has exclusive jurisdiction in respect of corruption and corruption-related offenses, and no one can come close. It was just impossible to do that because of Article 88. But with experience, Attorney General should always have an interest in terms of what is going on in respect of the conduct of criminal proceedings, investigation of criminal proceedings, initiation of criminal proceedings. Because at the end of the day, he is justice. Attorney General is justice. Everything any other agency does. In truth, the OSP is specialized, and it has a more focused approach to things. But whatever any agency does, it is to justice. And being Minister for Justice and Attorney General, that office should not be expressly excluded from criminal proceedings, conduct of criminal proceedings in that regard. So I won't go that far, but I will say we need to, once again, repeating myself, clean these things up in the general scheme of offense to make things more clearer.
I think this is my last question. Yeah. So my last question relates to a function of the OSP that I don't think conflicts with the constitutional provisions relating to the Attorney General, and that has to do with fighting corruption. I think the issues with the Attorney General has to do with initiation of criminal proceedings. But before initiation of criminal proceedings, every other function, we can legislate that anybody can do that. So in the area of fighting corruption, what do you think you can do? You've just mentioned corruption perception index ranking of public agencies. I think that under Section 2C, you are to take steps to prevent corruption. Naming and shaming can't prevent people from engaging in their conduct. So I think that you are well grounded in Section 2C if you do corruption perception index ranking of public utilities, public agencies and institutions. Beyond that, what new ideas do you have in terms of your functions under 2C, the objects of the office, to take steps to prevent corruption?
Honorable Chair, I think it should be obvious to everyone that we cannot fight corruption solely through the criminal law. It is also because we live in a society of ritualistic gift giving. if you happen to have the unfortunate situation, just by way of illustration, unfortunate situation of having your back wheel land in a gutter, and someone comes to help you out, the person is expectant that you will give him something. This society is, this is what we thrive on. It is a ritualistic gift-giving society.
I'm saying that it's not just your vehicle landing in the gutter, but in the case of MPs, even if he greets you, he expects again.
see where the problem lies. And because of that, it is very difficult to distinguish the acceptable from the unacceptable. And this is what is informing my drive if given the nod. That if I were to just focus on the criminal law aspect, that is to say, prosecution, I won't go far.
Quickly, do you have any agenda in relation to election campaign financing? I'm trying to focus the question. Trying to focus the question.
Thank you. You're done. Now, Obiamo first. Yes.
Thank you, Mr. Chairman. Congratulations, Honorable Kissi Agyebeng. You are famously known to be a very good criminal law lecturer and also a practitioner as far as criminal law is concerned. Now, we seem to have spent some time on the mandate of the office. Going back to the Act 959, specifically Section 4, where the mandate of the office is spelled out. And as you seem to allude, if the ordinary man wants you to explain to him what you are required to do as a special prosecutor, how would you put it? Especially where the impression has been created that your office is more or less not required or necessary, given that you fall under Article 88. I'm asking this specifically because of Section 4, because the impression is created that you fall under only 4.2. Well, if you look at even 4.3, it will expand your mandate. And probably we may not say that this office is not too necessary because of Article 88. Yes.
Honorable Chair, interestingly, when my name came up, my own kids were asking me, so Daddy, what is it that you're going to do if you're given the nod? In simple terms, the office is to investigate, prevent, prosecute for corruption, and manage seized, frozen, or confiscated property. But, Honorable Chair, in terms of the relevance of this office, the day we scrap this office is the day we say goodbye to our fight against corruption. Its relevance is borne out by its attributes and its uniqueness. It is unique as compared to all the other law enforcement agencies in respect of its mandate, because no other institution has been carefully thought out and designed to fight corruption specifically as Act 959 has done. And, Honorable Chair, in respect of this, the Office of the Special Prosecutor is the gold standard under the UN Convention Against Corruption and the African Convention on the Preventing and Combating of corruption. The international community, including Ghana, we ratified these conventions way back in the early 2000s, I think 2002 if I'm not wrong, that every jurisdiction requires such a specialized agency, which should be made independent, with a specialized trained staff to focus on the fight against corruption. Now, the, if I may say, flaw with Article 88 in terms of the Attorney General is that we sometimes require too much of individuals occupying the office of the Attorney General. Come to think of it, the Attorney General is a member of cabinet. He is part of the government. Independent would he be in terms of certain individuals if they were to fall foul of the law, if, for instance, they are also members of cabinet or members of the government? But in respect of the OSP, an agency, a person manning it, who is not part of the government machinery, who is independent, and Honorable Chair, giving the nod, I'm going to guard my independence jealously, who is resourced to undertake.
Honorable, in your family tree, how wide is your family tree?
It's an ending, actually.
Very well. So if you start from guarding your independence against them, your family, then you can guard it against everybody else. That's my charge to you.
Thanks for the footnotes.
Chairman, if I can
acknowledge
just
it.
honor Obi if you accommodated me. So, Kissi Agyebeng, just to get your own words, how independent will you be from the Attorney General, from the President of the Republic, and from friends and family members? Thank you.
Now, Chair, so far as I situate myself squarely in Act 959 and its four corners and province, my independence is assured. If I go beyond it, then I'll be on my own predilections. But the Act itself expresses it in so many words, and that should be enough.
Yes, Honorable, we're done.
Thank you. I would like us to look at Section 71 of the Act, plea bargaining. How do you think this aspect of the law or the Act can be implemented without the impression given out there, especially given your position, that this area can be compromised?
Now, fortunately, there is an arcane provision in the Courts Act where the Attorney General is also given the power to plea bargain by some sorts. A person pleads guilty, he coughs up the money, disgorges himself of the unjust arrangement, and the state is happy to keep the money, enter a sentence of conviction against him, but he doesn't serve a prison sentence. It is not unique. We already have that practice instituted. And clearly, this is meant to put some money in the state covers. What's good does it serve? For instance, if you just imprison someone who has hoarded millions for 10, 15 years, he comes back only to go for the money somewhere he stashed it. Better it is to recover that amount from him to make that activity costly. So, Honorable Chair, we already have a precedent in the Courts Act for this.
Yes, the last one is about...
This will be your fourth one.
No, third.
Third.
The last one is about the whole role of the board of OSP. Indeed, I have heard some board members
making comments about investigations of OSP. Would you say that, given the role of the board, they should be allowed to make comments on investigations which are being made by the office? And what are the implications of that?
Honorable Chair. Excuse me. Honorable Chair, the board is not supposed to interfere with investigations and the conduct of criminal proceedings. The SP, the Special Prosecutor, of course, answers to the board. But the Act itself clearly insulates the board from the investigation, conduct of criminal proceedings, and places it squarely in the province of the Special Prosecutor himself. So in that regard, the board should refrain from making comments and passing, let me say, judgment on ongoing investigations, because there is a high risk of a compromise. Leakage of information may arise, evidence tampering may arise. And it is in that wisdom that Parliament insulated the board specifically from initiation, investigation, and conduct of criminal proceedings.
Zero first.
Thank you, Mr. Chairman. Good afternoon, Honorable Nominee. Good afternoon, Mr. Chairman. Thank you very much for the opportunity, and good afternoon, Mr. Nominee. Mr. Nominee, before I go to my question, please, where is Damfa in Ghana?
At Imensa, you take the right down through Kweyman to Damfa.
So that's still in Greater Accra region or Eastern region?
That will be in Greater Accra.
Greater, all right. Thank you very much. Now, my first question to you, Mr. Nominee. In September 2013, at a symposium organized by the Dankwa Institute, you presented a paper. And the paper was titled, "The Decision That Wasn't the Decision, a critique of the Supreme Court decision in the election petition case," unquote. In this paper, you argued that the decision by the Supreme Court was somehow erroneous.
Sorry, I couldn't hear that.
You said, you argued in the paper that the decision was somehow erroneous. That, how do you juxtapose that position against the 2021 election petition hearing of the Supreme Court, where the EC chairperson was not made to testify under oath, which was actually central to the position of the NDC in filing that case? What are your thoughts on the Chief Justice's actions in reference to Honorable Dr. Dominic Ayini's comments, which were very close to...
Kindly take it one after the other. You answer one. You're putting two separate issues in one question. Break them up, please.
All right. His comments after the decision, which the Chief Justice took exception to, and was cited before the General Legal Counsel. What is your position in view that your comments, very similar to his, were never cited before the disciplinary committee? Thank you.
Yes.
Honorable Chair, Honorable Ayine is my senior in chambers. Actually, he taught me commercial law, the Faculty of Law then. But I would say here that, before I answer the question, the comments are dissimilar. They are dissimilar in the sense that in 2013, when I was delivering the paper at that symposium, it was an academic paper that I had presented. And my conclusion was that I couldn't find a ratio in respect of the so-called majority judgment in the first election petition case. And my reason was simple. Some issues had been placed before the court. Two main issues, in my opinion, as to whether, number one, the second respondent then was validly elected as president, and number two, as to whether the first petitioner then was validly elected as president. At the end of the day, when I read all the decisions of the 9 justices, I couldn't dovetail it with the outcome that was stated by the president of the court on that day in August of 2013. And this is it. It appeared to me, and as I said, this was an academic paper, it appeared to me that instead of answering the questions that had been placed before the court that day, the court missed those questions and was answering different questions. So whether or not the second respondent was validly elected, that wasn't answered. But what was being answered was, for instance, whether there was overvoting, whether there was voting without biometric verification. So instead of the president of the court stating on issue 1 whether the second respondent was validly elected, president of the court was rather stating how many judges voted on overvoting, 6-3. How many judges voted voting without biometric verification, 5-4, and the like. And to me, as a law lecturer, I didn't know what to teach my students at the outcome, because I'm seeing 5 justices saying that someone was not validly elected, 4 justices saying at the end that someone was validly elected, but I'm being held to say that the 4 justices were in the majority. Because I couldn't find a ratio in that case, that is why I made that academic exposition. And in respect of the 2021 decision, in terms of the comments by my former senior, I actually had cause during the pendency of the first election petition to deliver another talk before this talk you referred to. It was organized by the CDD and the National Media Commission. And there it was in respect of free speech and accountability and the rule of law. If we will recall, several individuals, private persons, had been hauled by the Supreme Court and cited for contempt. And my consternation was that it appeared as if immediately your name was cited and you were hauled in before the court, then you needed to start apologizing. And so those who apologized immediately were let off. Those who decided to bring in lawyers to defend them ended up in jail. And that was what I was pointing out in the first paper before this paper you referred to. At that time, the bar took umbrage at what I said, but I thought that I captured the conscience of the nation better by saying that, look, this whole issue of contempt as a criminal offense is so dangerous that if we are not minded to codify it, to define it well, and to come up with commensurate punishment, we will get to a situation where it will not be on national TV that day, but a high court judge sitting somewhere in Goso, there's no camera on you, cite you for contempt, jail you for 15 years. All you have to do will be to appeal. So I was sounding that caution, and that where we were going was very slippery road. And so we needed to rein ourselves in.
Honorable, before you come to this, let's go a little back into how did the concept of contempt of court develop? Was it by statute? It is never by statute.
No, it's what?
The courts generated that to protect themselves from executive abuses. Parliament generated its own contempt to protect itself from executive abuses because they have powers, they have the agencies of force. The courts don't have. Parliament doesn't have. So these two arms of government developed their own jurisprudence of contempt to protect the two institutions. So now, are you suggesting that Parliament should now make rules regulating how the court should now exercise their power of contempt?
Honorable Chair, absolutely. That is what I'm suggesting. It is dangerous, no matter how you look at it, if we are just to leave it the way it is. It is a common law offense, which has been accepted under the Constitution. But the danger, as I pointed out, is that because it does not have defined punishments for it, the punishment at some point may not fit the crime at all. And that is the danger. Because if you were to be cited for contempt today and say the judge gives you 2 weeks in jail, maybe you were let off. Same act placed before another judge may fetch someone 2 years. How do you justify that? It is a simple matter, in my opinion, of just delineating it. Okay, this act amounts to contempt. And in respect of this, if Parliament or the courts were to cite you for contempt and hold you liable, within these 4 corners, we can hold you liable. Honorable Chair, I think it is a safer course to go than to leave it open as it is. There is a clear and present danger.
Well, that's why we continue to have different opinions. But I didn't finish answering her question on Honorable Aine.
I believe I finished.
You're done. Very well.
Thank you very much, Honorable Chair. Honorable nominee, my second question has to do with a report by the Center for Social Justice, which suggests that Ghana has lost up to 1.89 billion cedis in judgment debts. There's a school of thought that intimates that these judgment debts sometimes are not particularly due to bad contracts being cancelled, but due to schemes that have been cooked up by senior public office holders, sometimes in collusion with international organizations, with local companies, just to fleece the state. What will you do? How do you think your office, the Office of the Special Prosecutor, can work towards eliminating this canker so that Ghana can save a lot of money? Thank you.
Honorable Chair, I believe I answered this question earlier when I intimated that our institutionalized risk assessment, conducting regular risk assessment in terms of the avoidance of toxic deals. That is what you refer to. These are toxic deals. And also the avoidance of judgment and tribunal award debts. And then I also intimated that I would do a systemic review of public sector institutions and the development of integrity plans. And that is where I waded into my corruption perception index idea of anti-corruption barometer of state agencies. That will have teeth and it will bite.
Thank you very much. My final question. A lot has been said about your age, and you've alluded to your experiences up to this point, which you think will be a good guide for you in undertaking your job in this office. How will you, however, navigate our cultural settings where we revere our elders in society, we revere the big man, we revere our chiefs? In terms of prosecuting your work, somebody is under investigation, goes to see Nana or Bahima, she calls you. How will you manage this within the context of our Ghanaian settings? Thank you.
Practically, simply, I'll have less friends. And that is why I alluded to my earlier statement that in the society of ritualistic gift-giving, gifts of goodwill, it becomes very difficult. And so just a reliance solely on the criminal law is not going to make it. Some practical, innovative things must come on board. If I start by having less friends, if I start by not picking calls, you will not approach me easily. But I admit, the honorable member is fascinated by it. I'll admit that, of course, if my village chief calls me and asks for a favor, it will be difficult. But, sorry? Oh. Yeah. It will be very difficult not to attend the call. But I said earlier in answer to an earlier question that if I place myself within the four corners of Act 959, I should be much more insulated from these things. But if I go out of it, then I open myself up for Jantua.
Very well. Honorable Minister first. Deputy Minister for Education, is that right? Yes. In that order.
Thank you very much, Honorable Chair. Congratulations, Mr. Kissi Agyebeng. It's amazing how you would drop one of my favorite names, William, which also happens to be the name of my father. Maybe you may consider transferring it to one of your prospective kids in the future. But I must congratulate you again, and going through your CV, the sterling legal credentials that you have, and listening to you, particularly on the innovative methods that you intend to deploy in the fight against corruption, I'm confident that you would succeed in the discharge of your mandate. However, there are just two concerns that I want us quickly to address. The first is your predecessor, when his nomination came up, was met with very high public expectations, just as your nomination has also been met with. But the public have very high confidence and high expectation in your delivery. However, some have held the view that your predecessor was unable to fully discharge his mandate and even to full term. So what assurance can you give this committee that when given the nod, you will see through the discharge of your mandate fully, and that somewhere along the line you won't throw in the towel should you encounter some challenges?
Honorable Chair, if I see through this office, I will be leaving at the end of a 7-year tenure on my 50th birthday. The gift I want to give myself when I turn half a century is that the OSP, solidly established, methodologically run in its deliberations, and its mandate is firmly placed on the map, that we may even become a beacon for our sister countries in our region to look up to. That's the gift I want to give myself for my 50th birthday. And so, my assurance to you, Honorable Chair, I'm going to see it through.
Very well, Honorable Chair, that would be a good legacy and a good gift, and I would encourage you to pursue so. The second and last concern here is that among many other criticisms that your predecessor publicly raised, one of it is that he alleged against you that you're representing some persons whom are under investigation by the Office of the Special Prosecutor. Now, when given the nod, which I'm confident about, how would you handle such matters in a way that you will not be conflicted? And how would you specifically handle such cases under reference?
Honorable Chair, once again, this appears to be a bit of a flight of fancy. It is not, if I may put it, true to say I represent persons who are before the OSP as suspects. It was in respect of one matter in which my firm represents a company, and the CEO of the company was invited to come and assist the OSP in respect of some investigation in the award of some contracts that the company did not award to itself. On the day that we appeared with the CEO of the company, the OSP could not meet with the person to interact with him. The meeting never came on, and as we sit here, it has never been recalled. So in that context, you cannot say that I represent suspects before the OSP. Once again, as I said, it's a bit of a flight of fancy.
Thank you very much, nominee and honorable chair.
Yes. Thank you very much, Mr. Chairman. I would also want to congratulate the honorable nominee for his elevation and appointment. As he has said already, he's been one of our favorite lecturers at the faculty. So, Mr. Kissi Agyebeng, congratulations. Now, my very first question has to do with investigation and corruption-related matters with respect to the appointing authority. The government of the day is giving you the opportunity to serve in this capacity. The Akufo-Addo administration has been hit with several corruption-related scandals. Oh, please, these are matters of public. So, for example, we've had contract for sale scandal. We've had PDS scandal. We've had cash for C scandal. We've had the Kelning GVG scandal. We've had issues of visa, Commonwealth visa scandal. We've had issues of Ghana Maritime Authority scandal. We've had issue of the Bost 15 million contaminated fuel scandal. We've had issues with respect to Ameri deal. Now, my question is that how committed are you to investigate corruption and corruption-related matters under this government, particularly when one of the complaints by your predecessor was that government did not give him the needed support to work as an independent special prosecutor?
Honorable Chairman, Honorable Member, I thought you were going to refer to investigation of any of these specific acts you have enumerated. But you're zooming off them to general questioning. Those ones, are you interested that he investigates any of them that come under his mandate? That's what I would like you to. Yeah.
I'm sure his answers would prompt some of those.
Honorable Member, Honorable Nominee, he listed a number of issues he calls scandals. Do they fall under your mandate? Are you interested in investigating any of these if they are still pending?
Honorable Chair, this is what I would say. I would approach all cases of alleged corrupt and corruption-related issues with the same objective, ruthlessly.
So how do you intend dealing with funding of the and then its associated challenges for the Office of Special Prosecutor? Because I think one of the complaints, again, of your predecessor was that he didn't have sufficient funding. And even though later on we got to know that even the money that was made available was not used by the office. How do you intend dealing with this situation?
Honorable Chair, the first occupant of the seat indeed had no president. He was the first occupant. Before him, there was no one else. So whatever he faced there, I would like to believe were what I'll call teething problems. I would draw from the wisdom of the hindsight of the problems that he faced to chart my own path.
Mr. Chair, as far back as 1970, Justice P.D. Enin reports as follows in paragraph 141 that a deadly virus, he described corruption as a deadly virus that is eating its way into the body politics. If it is not checked and brought under control, it will seriously undermine the effectiveness of the present and the future government of Ghana. And that is as far back as 1970. One of the reasons why the Office of Special Prosecutor was established was to deal with issues of corruption. As we speak today, the corruption perception index is negative when it comes to this administration. And indeed, public confidence in the Office of Special Prosecution has really dwindled. What would you do to increase public confidence in the Office of Special Prosecutor?
Honorable Chair, the last corruption perceptions index by Transparency International, we scored 43, which is actually the world average. And African average, I believe, is around 32. We are not doing so bad. But we need to go beyond. Yes, it appears we've been a bit stagnant on that trajectory.
But that was a reduction compared to 2016. Very well.
Some of the things that I intend to do, I've already stated, Honorable Chair. And I would like to add that I would also I'll be engaging the civil society organizations, the non-governmental organizations, community-based organizations, and investigative journalists. And in this quest, 9th December is International Anti-Corruption Day. Why can't the office stage a conference annually, bringing together experts, corruption watchers, to assess Ghana's progress? And here it is not a talk shop. That is not what I'm interested in, but a platform for peer review. It is one aspect to assess our progress and to encourage ourselves to go further. And then again, the office itself needs some reflection, because if care is not taken and the OSP itself becomes corrupt, then the battle is lost. And so I will institute internal measures to ensure that there is no abuse and integrity of the office is upheld at all times. I would also engage the Chief Justice and the Judicial Service to accommodate the OSP by pushing for the establishment of specialized courts when it gets to the leg of prosecution, specially trained judges, judicial officers, in order to quite effectively bring an end more timeously and in a better nuanced way in respect of the initiation conduct of prosecutions. I have also thought about, and I'm going to give it a push. Why can't we institute, for instance, an academic discipline in applied anti-corruption studies with partner institutions? We must start from somewhere, and building on that, in that general scheme of affairs, the body politic itself will feel that, look, we need to do something about our fight against corruption, and the feasibility of the OSP out there engaging in all these activities. And then its legal operations in terms of the initiation and conduct, investigation of criminal proceedings, married together, will go together in assuring what the honorable member is asking for. Mind you, I said earlier, Honorable Chair, that we cannot fight corruption solely through the criminal law.
Yes. Thank you, Mr. Chairman. And let me congratulate the nominee once again. Mr. Chairman, a co-conflict, he said? Mr. Chairman, since receiving the nominee's CV, I did some work on him, speaking with a lot of his people that I know who know him. And this is a summary of my findings. But one worries me. You are known by your peers to be honest, principled, a fine gentleman, frighteningly knowledgeable, and loyal. The Chairman, my question to the nominee is, if you are considered by your peers to be very loyal, if those people are found in your net, those you are loyal to, how are you going to deal with them?
Now, remember, thank you for the glowing findings you made about me. Now my loyalty is going to be to Act 959.
Mr. Nominee, apart from page 1 of your CV that talks about...
Just a minute, your loyalty will be to the act or to the state of Ghana?
Invariably, that is it.
No, I just want clarity. The words are not interchangeable by my understanding of it. For instance, even the Constitution, you would owe and subscribe to it. Loyalty to the Constitution, you've just picked an act of parliament. You are an officer of state, and the concern in Ghana, probably what informed the decision of the president to appoint a special prosecutor, is the inability of political appointees at the level of the Attorney General to deal with the virus and menace of corruption. Now you are narrowing your loyalty to just the Special Prosecutor Act. Is that my understanding? Or to the state of Ghana?
Loyalty to the law, the laws of the Republic of Ghana, the Republic of Ghana.
Thank you, Chairman.
Honorable nominee, apart from page 1, your biodata, page 2, everything talks about law. Page 3, employment history, law. Page 4, law. Page 5, law. Page 6, leadership and positions, law. Page 7, in fact, even a Kwafu Hall Junior Common Room, legal secretary, law. Conferences, capacity building programs attended, every single one of them, law. Publications, law. Selected papers, law. In fact,
honest notary public law, we have one football activity passing through. Mr. Chairman, I want to find out from the nominee, do you have any other life? What makes you happy?
Reading the law.
Honorable Chair, what makes me happy, I cannot disclose on my CV.
Is that the answer to the question? You have to be a well-rounded person.
Honorable Chair, what I mean to say is I'm very well-rounded. It's just that the CV came with guidelines. So I tried to follow the guidelines of the House. But what makes me happy, the guidelines did not capture those things. So I couldn't put them there. But Honorable Chair, I signify that I like walking. I like to trek mountains. I climb a lot. So at least that's some social life. Being from a mountainous area.
Mr. Chairman, on a lighter note, the nominee said he was from Kwewu. I know him to be from Kwewu. But he made a mistake by saying that his favorite Kwewu food is fufu and nkakra. The Kwewu food is fufu and decolonized apine.
Honorable Chair, I didn't want to cause an uproar by going there. But correction duly noted.
Chairman, thank you, Mr. Chairman.
What did you say? Decolonized apine? Is that the one they call Air Force?
It's decolonized apine, but fufu and decolonized apine.
I see. That's right. Yes, Honorable Suyini.
Thank you very much, Honorable Chair. Honorable nominee, it's on record that I had some reservations with regard to your predecessor, but I had nothing wrong with, I had no reservation as far as his politics was concerned, because I was very confident that he was not going to be easily swayed by partisanship. So I didn't have a problem with his politics. On the contrary, in your case, many don't seem to know your politics that much. But so many people have expressed reservation about your possible partisanship. And I'm sure it's only time that will indicate if there are reservations, will hold water. I'll start on that note, therefore, to ask if you get invited and do attend meetings of leading New Patriotic Party members to discuss what you may call high-profile partisan complex legal cases.
Honorable Chair, are you saying I have been or I am going to be invited?
Do you get invited and do you attend?
No, Honorable Chair.
Okay.
No to both.
Now let me take you back to an earlier question relating to what you refer to as an academic paper that you presented with regard to the 2012-2013 election petition. I have gone through the paper, and I just wish to share two quotes with the permission of the chairman. First one, quote, "If the pink sheets were so unreliable, will they form the basis for the declaration of a president?" Unquote. Second one, "I want to tell their lordship," that's quote, "I want to tell their lordship
that it is not merely easy to say that by some rebuttable presumption of evidentiary setup, that official acts are presumed to have been validly done. Therefore, the figures as provided by the EC are presumed to be correct, especially where in this case the EC itself admitted, though tenuously, that irregularities were recorded in respect of the elections, unquote. Now, based on these views, and based on the knowledge that, for example, the Electoral Commission in their final declaration declared multiple results before they finally, came with the last one. What is your view on the outcome of the 2021 petition in relation to how the Electoral Commission was presumed to have done the right thing, given these two quotations especially?
Now, Chair, there were dissimilar circumstances, once again. In respect of the first election petition, those quotes emanated from some pronouncements of the judges, some of the judges. Some of the judges went to say that the pin sheets that were brought to court were so unreliable they couldn't do anything with it. That was my understanding of what they were saying. So I was asking a question. That if the pin sheets, which forms the basis for the declaration of a president, that you saw in court, are so unreliable, how then do we have a reliable outcome? Because that is the primary document, if I'm not mistaken. And then the presumption that the official acts are presumed to have been validly performed. This is when the act has actually been performed. Then you come out with that presumption, and anyone who has issues with it will then come trying to rebut it. But in respect of the 2012 election petition, the official act I was referring to had not been performed. And this was it. The refusal or neglect of some of the returning officers to sign on the returns. The act hasn't been performed. There is an absence of a person's signature there. So if you go ahead to say official acts are presumed to have been performed, I was at pains to understand and wrap my mind around as to how that presumption can be raised here when there is no signature. So I actually said that. Did we bother to find out from those returning officers as to why their signatures were missing? In respect of the recent election petition, that's a totally different matter, in that an act had been performed. The allegation was that it wasn't performed well and there were infractions. Totally different situation from where the act wasn't performed at all. Now, if you come to the conclusion in respect of the recent one, that though there were some mistakes, though there were infractions, but you can still make sense of what occurred, that to me is a different matter from where the act wasn't performed and you are raising a presumption on it to come to a judicial conclusion.
Well, I only litigate it further. I'll move on, just except to say that just like the unreliable pink sheets, it perhaps would have been appropriate if you are minded to comment on it for the Electoral Commission to defend whatever errors happened until the final one, and not for the judges to presume that what was finally declared was the one to rely on. But I don't want.
Are you referring to the trial strategy?
Yes, partly so. But like I said, it's not. I don't want to litigate it further. I will just move on to my next question so that I'm not, bailed out by the very generous chairman this afternoon. Another question that you were asked by Honorable John Kumar. I would want to do a quick follow-up on that. You have worked closely with Anas Amiri Anas. The president, in opposition whilst campaigning, promised to use a principle he christened the Anas principle to fight against corruption once he was elected. Unfortunately, we haven't seen that. Indeed, some of his leading members have rather been on a warpath and have gone to great length to discredit the Anas principle. And in fact, even in the question, it's not one person, even the question of John Kumar, he talked about school of thoughts. And one of the thoughts was to say that that method of gathering evidence is not to be admitted. So it's not one person. So I'm saying that they have gone to greater length to discredit that principle. Knowing your relationship with Anas Amiri Anas, you have defended that principle in court. Now, your office will require that you gather information, you do investigations. Since the president has failed to implement this principle and have had some of his members criticize this principle, is it a principle, and you have worked in defense of that principle in the past, is it a principle you will consider to use in your fight against corruption? And can you count, or do you expect the president to fully support you on this?
Honorable Chair, as I quickly reminded an earlier questioner in respect of the Anas principle, and that was clearly an indication that I fully subscribe to that principle, and I'm going to use it. Indeed, I also said in an answer to a previous question that I will be engaging investigative journalists in respect of my work if given the nod. I say so because I have intimated that corruption is so secretive and complex, and that unless the participants are coming to you to report themselves to you, it is almost impossible to find it out. Now, if someone can go underground and through a sting operation come out with some evidence which has probative value, I am all for it, and I'm going to use it. I hope I've answered your question.
There's a second part. Given the attitude of people close to the president in relation to this principle, can you count on the president and his government's support?
Upon my consideration, I had full assurance. It is one of the reasons why I'm sitting here, that I'm going to count on his full support in making this office successful, making it work, making it effective.
Well, your predecessor told us the same thing.
As I keep saying, I won't be wearing his shoes. I'll wear my own shoes.
I'm just putting it on record that he told us the same thing, and now he's saying something different. So I wish you well, though. Finally, you spoke of Article 88, 3 and 4 of the 1992 Constitution. And that got me thinking. Corruption is a high-risk, enterprise. And to fight it, one will need to be very well prepared, because those engaged in it will go at any length to frustrate the fight. Now, you suggested in that answer that the OSP may be unconstitutional, because you talked about the need to clean house because of the, especially 88.3. Why did you accept to use this tool that can be challenged by those who may see it as a threat?
Honorable Chair, I was by no means suggesting that it's unconstitutional. I was just admonishing that we need to make things clearer, and not just in respect of the Office of the Special Prosecutor, the other agencies too. That was my call. I'm never suggesting that it's unconstitutional. I said the concerns I had initially when this process began as a bill and all that, I communicated to the Attorney General then unofficially. And those concerns...
And you said it bordered on the constitutionality of the office. I quoted you.
Yes, the constitutionality when it was mooted, not the constitutionality of the outcome, which is Act 959. They are different things. My concern was that if care is not taken, the Attorney General will be upstaged, judging from Article 88. And so, in order not to upstage the Attorney General, certain provisions ought to be added to flesh it out, to keep Article 88 as it is, whilst adding to it Act 959. And largely, that has been achieved in Act 959. But I was saying the cleaning of the house, I was referring to that. A bit more work has to be done to make things clearer. As I said in relation to an earlier question, the mother problem is 88.3. If we are able to dovetail it better, it will make things work more effectively and efficiently. So it wasn't a suggestion that 959 is unconstitutional in my opinion. Not at all.
Okay, can I suspend sitting for 10 minutes?
President Paul.
Congratulations, Mr. Kissi Agyebeng. He's my lecturer at the law faculty. Indeed, Mr. Chairman, when he returned from his further studies, at the time that he came back to the country, Professor Henrietta Mensah-Bonsu was then teaching us criminal law. And she got an appointment, a United Nations appointment, and he took over from Professor Henrietta Mensah-Bonsu. Those were big shoes indeed. Very, very big shoes. And he's been at it, I believe, for the last 14, 15 years. And I have no doubt at all that stepping in another big shoes of the former OSP is not going to be a very difficult task for him. So I wish you well, sir.
Thank you.
Mr. Chairman, now, since the creation of the OSP, I believe the building blocks have not been fully put in place. It means that there's a lot of work in terms of staffing and then getting all the tools that you need for a smooth takeoff. Now that, for me, is very, very important in the kind of legacy that you believe in at the end of your tenure as a special prosecutor. One very, very important thing that for me I think you should look at is the remuneration of the staff. If the staff are not well remunerated, you stand the risk of having, people who will be easily compromised. They will pretend to be working, whilst we pretend to be paying them. So, Mr. Chairman, this is one, area that I believe that my lecturer should be looking at. Now, this, for me, I'm not sure you should be responding to those commentaries. They're just areas that I am just bringing to your attention. Mr. Chairman, one other thing that I think you should also be looking at is also the perception that the public would have about your staff. And you have taught us, in matters of not being a judge in your own course, the tests, reasonable suspicion tests, and then real likelihood of bias tests. I think all these tests would have to guide your staff. I believe you have enough experience in this area, so I think that the best part of your work would be in how you get your staff to align with you properly. Mr. Chairman, the question that was asked by Honorable Bright.
All that one was what?
Mr. Chairman, my big brother is here. I'm warming up. I'm taking a leave from my big brother. Mr. Chairman, the question that was asked by Honorable Brian Champon regarding, on the lighter side, what do you do, outside of the law? I believe I know some, because I know the Kissi Agyebeng that I know like to chill. You like to chill, you like to party, and all of that. That has to be said. Now that is going to be something that you can't do anymore. How do you, wind down? How do you wind down?
When you say he can't do that anymore, what's the legal basis?
It's a public.
It's a habit that he has
may meet
for a
the
long time.
corruption in the dance floor, the bus.
Honorable Chair, that is why I said that for the guidelines of the CV, I couldn't disclose some of these things. But those who know me know that I'm a well-rounded, social, and affable person. Honorable Chair, maybe I'll retreat into private parties.
Mr. Chairman, I don't have much to say except to wish you well. I wish you well, all the best, sir. Thank you very much, Mr. Chairman.
Thank you very much.
Are you done? Yes, all right. Yes, Gisela, sorry.
Thank you, Mr. Chairman. Good afternoon, nominee. Congratulations. You are leaving a practice that you have formed, being a managing partner, with a lot of qualifications and areas of specialization. I looked at your profile. Going to sacrifice about 7 years of your prime, of the prime of your life, to be in this position, considering what my colleague has just also mentioned about your social life. That's that aside anyway. Are you ready to sacrifice that 7 years? You mentioned that you would want to achieve something by age 50. Is that no more? Isn't that more egoistic than nationalistic in your aspirations for this office?
I've had much thoughts about it when I was approached to take up this office. And it is a sacrifice in so many ways. But I also see it as a call to duty, a national call to duty. And so if I'm well placed to serve my nation in this position, I will do so. My allusion to the half-century gift is at the end of the day, if I see through these 7 years per the statute, I will turn 50 exactly at the end of my tenure. And the gift I said I would want to give myself would be a very established, effective and efficient OSP. So in that sense, egoistically a bit, but the outcome is that I've given the nation something to be proud of. So that is nationalistic.
Very well. Thank you, Mr. Chair. Would you be bold enough to prosecute, to investigate, maybe prosecute, if the need be, a sitting president, a sitting chief justice, or any of such?
Honorable Chair, within the bounds of the law, we are all equal before the law. And I've already answered this question. It is not as if the office has been created for certain individuals. Indeed, it is for all of us. And I said earlier that I'm going to approach this duty with ruthlessness. So all cases of alleged specific instances of corruption and corruption-related issues, I'm going to look at it with the seriousness it all deserves. And I said earlier that I cannot claim to halt corruption. It is human nature, one way or the other, to engage in criminality. That is why the law is made for persons. But the bottom line is that I'm going to make corruption very costly to engage in. And if it is costly and it becomes a very high-risk activity, you would think twice before you engage in it, because you know that Big Brother will be watching.
Thank you, Mr. Chair.
Yes, yeah.
Thank you very much, Chairman. Congratulations, Mr. Agyebeng.
Thank you.
My teaching assistant.
Honorable Chair, sorry, place it well. Maybe a bit of levity. I was your teaching assistant. So, the way you place as if you were my teaching assistant.
But you had already said that. Our teaching assistant.
We don't take seniority lightly.
Our teaching assistant.
In the legal profession. Thank you.
In 2004, you were our teaching assistant. And we thank you so much. Chairman, I want the nominee's opinion on this. The Constitution under Article 94(2) defines the qualification for member of parliament, or who qualifies to, or who is well suited to take the position of a member of parliament. I think 94. It's on qualification. Is it 94? Yes. And it also talks about, especially 94 2A, that a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana. And if you also look at the Citizenship Act, it's also, I think, under Section 8, as amended by Section 16, Part 3 of the Act, also lists certain category of positions that holders of dual nationality cannot occupy. Recently, we've been receiving certain petitions and proposals from our brothers and sisters from the diaspora that those aspects of the Constitution are, in their view, unconstitutional. It bars them from actively participating in certain aspects of our national life, to the extent that there's a sitting member of parliament who is leading the group that has even called on the speaker to, as it were, lobby the House to ensure that
Honorable Yeboah, since we have defined his mandate, well, don't you think this question should go to the Attorney General?
Mr. Chairman, I said I needed his opinion because of those positions, and especially in the area of corruption. I'm coming there because their view is that they are being barred unconstitutionally by the Constitution because they are dual nationals and they are not being given the opportunity to serve the country in those roles.
Honorable Yeboah, I have to apply the rule strictly, as suggested by Mr. Speaker yesterday, and by Order 67(1)(e). A question shall not solicit the expression of opinion or the solution of an actual legal case or a hypothetical proposition. Kindly ask another question, please.
Yeah, this refers to questions to Minister. Oh, okay. Well, I don't want to challenge the chairman, but it's okay.
You don't have the power to.
Because I know it refers to questions to ministers. Thank you. But Mr. Agyebeng, let's go to your law. Under Section 79B on politically exposed persons. Peace. Do you think the definition is exhaustive enough to curb corruption and corruption-related offenses?
Honorable Chair, the definition section actually says it includes. So it's an inclusive definition rather than an exclusionary one. And so it will not just be pigeonholed there. When you go to the commencement sessions of the Act, it tells, actually, not just the commencement session, the long title of the Act itself tells us that it is in respect of public officers, politically exposed persons, and persons in the private sector. So it is all encompassing enough to fight corruption in that context, in that sense. You look at the long title, it is stated there. And then the commencement sessions.
That takes me to my second question on tracing. Corruption, like you rightly said, is a highly sophisticated offense or crime or enterprise. You have been given the power to be able to trace immovable properties, movable immovable assets or movable properties illegally acquired. Do you think you have, as the office as presently set up, has the capacity and the strength to be able to trace properties or acquisitions illegally acquired, especially with this technological advancement?
Honorable Chair, it is, and it should be, because otherwise then the fight is at a knot from the onset. And I said earlier that it transcends national boundaries, and that's why Parliament passed the Mutual Legal Assistance Act in 2010, Act 807, to help in this regard in respect of foreign partners and foreign nations, especially in this regard, because if the proceeds of crime are being wired in from some sources, you may not have the wherewithal and the power to rein them in. But Act 959, marrying it together with Act 807, tell one that you need to cooperate with all these agencies, both in and outside of the country, in order to come to an effective work plan, because without that, you will not be able to do much. So the way it's set up under Act 959, with acts like the Mutual Legal Assistance Act, with acts like the Whistleblowers Act, Witness Protection Act, and the Anti-Money Laundering Act and the IOCO Act and all that, if we cooperate enough and we come together with a composite plan, we should be able to achieve the objects of all these acts, and specifically here in this context, Act 959.
Will you be frustrated if, for example, you are investigating a matter in which you needed the support and cooperation from, let's say, our brothers within the sub-region or elsewhere, especially if you need a particular evidence from that jurisdiction and it's not forthcoming to enable you secure conviction? What would be your attitude and how would you feel as an SP, especially when Ghanaians would think you, excuse me, failing on the job, especially with respect to that particular matter?
It probably will be frustrating, but you know, all these nations are also state parties to the UN Convention Against Corruption and the AU Convention on the Prevention and Combating of Corruption. So that is where we will draw the mandate to remind them that, look, we need to be working together. Today, I may need them, if given the nod. Tomorrow, they may need me if the funds are being transferred the other way. And so it is called for cooperation under all these conventions. And indeed, I keep referring to the Mutual Legal Assistance Act. It is also one of the gold standards under the UN Convention Against Corruption. That is what we have domesticated here, and it should be replicated under the convention in all these states.
Thank you, Honorable. Very well, so I can come to leader. Oh, you're here. All right, you may tell.
Thank you very much, Honorable Chair. Council, congratulations.
Thank you very much.
Good to see you again after a long time. Have you cited the resignation of appointment as Special Prosecutor letter by your predecessor, if you are giving them?
Sorry, can you?
Have you cited the letter of Honorable Martin Amidu, his letter of resignation? Have you cited that letter?
Honorable Chair, another disclosure here before I go on. Honorable member was here behind me at the faculty and at Makola, and we were closely associated. I have a lot of disclosures here today. So, I heard he had resigned. I haven't read the letter.
And to disclose also that you used to give us grandfather notes. Okay. I'll, with the permission of Honorable Chair, read a few portions to you. He says on page 1 that, oh, just a few portions. He says, limited transaction convinces me beyond every reasonable doubt that you had labored under the false belief that I could hold the office of the Special Prosecutor as your poodle. I move to another line, very simple, page 2. It thus became abundantly clear to me that I cannot continue under your government as the Special Prosecutor because we disagree on the non-partisan independence of the Special Prosecutor in the performance of the functions of my office. Even though you've not seen this, I've realized that a lot of questions have been asked from this. If you find yourself in this situation with the president who appointed your predecessor, what will you do?
There are two choices open to a person. You either resign or you go ahead. Of course, I persevere. And if my conscience and my learning of the law, as I said, are going to be my guide, my first inclination will be to persevere along, because that is my calling, and that is the oath that I have sworn. Unless it becomes so unbearable, then I will say the Republic should take its job. But I am not that kind of person. I am not predisposed to that kind of open confrontation in that regard.
We have disclosed what we know about each.
I've been listening attentively to the Honorable Nominee's submission, and I heard him mention that he has a law firm. Thinking about the position he's going to inherit, what will happen to your law firm if given the
Mr. Chairman, let me also say that before, in his attempt to answer a question, he also tells the relationship. When I had to go to Shrad in 2010, I had to contract Yine and Feli, right? Is that the name? And he was then one of the associates, right? And he virtually was the one who led me throughout. It's just so unfortunate that after that incident, even though I paid all my legal fees, I don't think we've met again since.
I believe you paid the fees to Bogatanga is MP. But I
paid it to the firm. So I want to believe that was on the lighter side. Mr. Chairman,
I want to ask to determine whether he is eligible to ask questions. Since he is a confessed client, is he eligible to ask questions?
Have you heard a very satisfied client? I'm sure I'm very satisfied. Well, Mr. Chairman, going through his CV, I mean, undoubtedly, you see that he's very hardworking. You see through the CV. But my concern was between 2006 to date,
in respect of my life at Legon.
Mr. Chairman, he was answering a question earlier about his law firm, and he said the firm will continue to run. I wanted to know what will happen to your role as a special prosecutor if this House grants you leave vis-a-vis the firm.
As I stated earlier, there are clear rules of succession there. And so there's someone already jogging on the sidelines waiting for me to assume my seat. And so it's going to be a smooth transition. I intimated that at the end of my life as a special prosecutor, I'll swing by again, perhaps in another role.
The question is, what will be your relationship with the chamber when you are confirmed as a special prosecutor?
Honorable Chair, I believe that is what I'm answering, that I'm hesitant. Someone is ready to take my position. That means I'm hesitant. At the end, I'll come back.
Chairman, that's exactly the worry, because this act that you said you are going to be very loyal to in 13.7 has this to say: the special prosecutor shall not, while holding office, hold any other public office or engage in any commercial venture. So you just handing over to someone, go become chief special prosecutor with the permission of this House, 7 years later come back, means that even whilst you are the special prosecutor, you may be earning from that firm, because that firm, you've not cut ties with it. But you've not cut ties with it completely. So this is what the Act is saying you should not do. So that's why I'm asking, how is your relationship with the firm going to be when you become the special prosecutor?
Honorable Chair, even as we speak, I don't earn anything from the firm. I manage it, but I don't earn anything from the firm because I'm a managing partner. This is the thing. I created it. For all intents and purposes, is going to be partly owned by me. That is not going to change. I'm not going to divest myself of the ownership of the firm, if that is what you mean. But what the Act is saying here is that I shouldn't engage in any commercial venture. I'm not going to engage in running a firm. I'm not going to engage in its day-to-day activities. I'm not going to mind myself as to what is going on there. But the fact of part ownership remains. That is not an engagement properly so-called in the way it is put here. Unless the suggestion is that maybe I should sell my ownership in the firm or divest myself of it, which I don't think that's what is being referred to here.
Well, Mr. Chairman, engaging in commercial activities in the real sense is not necessarily your presence being there. This is a firm that you own or you partly own. If it runs very well and there are dividends, those dividends will be shared and you'll be entitled to your share. And this is what the law frowns upon. And that is why I'm asking, how are you going to relate to that?
Honorable Chair, let me state emphatically. Throughout the 7 years that, given the nod, I'm going to be the special prosecutor, I will have nothing to do with the firm. I am only saying I will come back after my life as the special prosecutor because I created the firm. But during my tenure, there will be no relationship between me and the firm.
And you also ensure you don't earn anything from the firm?
And I intimated that even now I don't earn.
Maybe because now it's not making so much money as a company.
That is not the reason. It is because we decided on how to run things for a while.
Okay. But will you consider probably applying to the Speaker of Parliament, just as many of us have done, for a waiver? Office of Profit. Because you are a public officer. Even though I am sure that it is with ministers and members of Parliament, I'm not a lawyer, as you may know, but looking at the constitutional provision, I may want to believe that you equally may qualify to apply for that. All of us who have businesses, we don't really run them, but disclose them, get Parliament to sit on it, go through and be sure that the role that you'll be playing will not conflict with the businesses, and then Speaker gives you a certificate, and then you run it. Will you maybe look at the possibility of considering that? Just to make sure that you are on the safe side.
Honorable Chair, I will explore it.
Mr. Chairman, I know Honorable James Agaga is a friend. Am I right?
A close friend.
So is Gabi Asare Ochidako your friend?
Mr. Ochidako is my professional colleague. He was my mate at the Ghana School of Law between 2001 and 2003. My firm has represented him in several defamation suits.
Well, have you worked together? Have you done any job together?
Can you make it clearer? As in personally?
You own a firm. You are a lawyer. I mean, you are a business person, I want to believe. Have you done any job together?
As in firm to firm? Is that what you mean?
Whether it is as you as Kissi Agyebeng or Cromwell Gray, or in any form, have you done any job together?
Not with Mr. Ochidako, not with his law firm.
So you've not been involved in any business that he is also related to?
As I said, we have represented him in several defamation suits.
So except the defamation suits, you've not worked together?
We have been involved with a law firm that is also involved at some other end with them, but not my law firm with his law firm in any transaction.
So have you worked for GMPC?
Yes.
So you are currently working for GMPC?
As one of the external solicitors, yes, Cromwell Gray.
Is it in relation to the LNG regasification project in Tema?
That was one of the one-off transactions. But at present, we are on their record as one of the external solicitors in respect of local matters. In respect of the LNG project, we were local counsel, not to GMPC directly. Cromwell Gray was local counsel to White and Case LLP in London. So we were advising White and Case LLP in London in respect of its brief with GMPC here. So we were not GMPC's counsel on that matter in that sense. We were counsel to White and Case LLP.
So, but you said the records of GMPC will show that you've done some work for them.
Yes, we have prosecuted 2 cases on their behalf, one at the High Court and one at the Supreme Court.
How did they procure you how did they procure your service?
GMPC, by reason of the fact that they became acquainted with us when we worked on the LNG project, because our work output to White and Case was showing up in their briefings, and so they showed an interest in us.
So you know that GMPC is a public entity, and in their procurement of services, they are supposed to advertise for competitive bidding. Did you go through this?
Yes, we went. I believe they went all the way to the PPA.
I'm only asking whether you saw it as an advert, it was an open thing that you went and with others and competed to be either nominated or selected to provide that service.
We applied.
You applied?
Yes.
But you weren't sure whether the procurement method that they use were competitive or sole sourcing or restricted. You are not conversant with that.
The process that was gone through is that with all the documents and records they were asking us for, it was all designed in respect of a procurement process. Otherwise, they would not be requesting the documents they were requesting from us. And Honorable Chair, mind you, at that time, as I said, they already knew us, they already knew our work product. But then to insist we come through that channel again clearly shows that they were going through some procurement process. Otherwise, it would have been just an automatic appointment after the LNG project.
So you rightly mentioned the White and Case as a company that you have worked with.
Yes.
And do you know some of the leading partners in this White and Case?
Those we worked on the LNG project, yes, and not all of them.
So you know Joshua Sian?
Very well.
Is he your friend?
He's my professional colleague.
And you work very closely together?
Yes, we had to on that project.
Earlier when you were asked about Japan, you said you virtually didn't even know anything about it until the issue came up. Is that what I heard you say?
Yes. The first time I heard about Japan, Honorable Chair, was when Mr. Shidaku called me and said that he had been defamed by a certain MP in respect of the deal, and instructed me to sue defamation on his behalf. And that is when I started researching as to what it was all about and the veracity, justification, or otherwise of what the certain MP had said. Because if I was going to maintain a suit in defamation, I needed to place it in that context. That was the first time I was hearing of the deal. So I will state again, by no stretch of the imagination was I connected to it.
But working very closely with Joshua Sian in the White and Case, you are very much aware that White and Case was also working with African Legal Associates, which is owned by Gabi.
And that is why I stated earlier that we were involved with a firm on a project, which was also involved with ALA on other transactions, but we were not involved in those transactions.
And you know that this White and Case with Africa Legal Associates were deeply involved in the Ejapa?
I have no idea.
In the announced Amidu announced case, you were the lead counsel for Anas, Anas. Is that right?
There are several cases, but yes, we have represented in all the cases. Honorable Chair, just some levity. The one who took the fees in respect of the Honorable Ranking Member's case has just arrived.
I thought it is your firm that took the fees, because the receipt that was given me was not in either Kissi Agyebeng or Dominic Ayini. It was in Ayini and Feli.
The name Ayine is instructive, that it was going to Ayine.
Chairman, that was on the lighter side. You said that you virtually led them in all the cases.
Yes, Honorable Chair.
So did you have unlimited access to the video recordings?
Yes, I did. Indeed.
Especially in the case of the judges?
Yes, indeed. Before I would sign off on any process, a legal process, I would ask Tiger IPI and Mr. Anas to sit me and all my team together and go through painstakingly the raw footage, the raw data of all these investigations before we come to a legal conclusion. We have to go through that exercise. So what the public sees is the documentary. What we see is the raw footage, which forms the legal basis of the actions, whether the outfit is a plaintiff on a matter or is defending a matter.
I mean, obviously, I can attest to that, where you ask, just tell me the whole truth. Let me know exactly what the thing is, so that I can defend you.
Exactly.
So yes, I know about that. But were some of these videos, some of the judges spared? Were some of the judges in the video spared?
Not at all.
Is it not at all, or not that you know?
No, not at all. There was one video that was scratchy, it was unclear. So with that being grainy and you were unable to tell what is on it, a lawyer, I would not advise that we carry that through. But no one was spared.
Going through that particular case, what do you make of our fight against corruption, especially in the judiciary?
Honorable Chair, I'll put it more generally. There's a lot we still need to do on all levels, in all spheres. It's the way our society is arranged. And that is why I keep referring to our setup of ritualistic gift giving. Because how do you differentiate between an acceptable gift and an unacceptable gift? We need to still have that conversation and to move ahead on that.
Mr. I just want to find out, in 2019, you were made the chair of the Electronic Communication Tribunal, right?
Yes, Honorable Chair.
Did you have resources to be able to work?
I would wish for more. Indeed, in my handing over notes, given the note, I'll have to exit. In my handing over notes is one of the things that I'm going to talk about. And I would wish that the funding of the tribunal is divorced from the regulator. Now, it is a very invidious position to be in, where your perpetual respondent, which is the regulator, is also your paymaster. Now, if your respondent, forever respondent, because it is always the respondent, it is never the appellant, because of the way the act is. If it is also your paymaster, if on an occasion you get people in charge who are not this crop of persons, I would say we've not encountered things like that in respect of them, but we shouldn't base legal operations on the goodwill of persons and individuals. So if you make the regulator the paymaster of the tribunal that's supposed to sit in an appellate function over his decisions, naturally it will be unhappy. I pay you so you sit on my decisions and then rule against me. If we separate that association and channel the funds for the operation of the tribunal from another source, the tribunal will be better placed to do its job. But there's always a case of hamstringing if you do not meet a right crop of persons, or if there is that clear danger of a friction or a conflict. Because if I were to come out with a decision tomorrow that is unfavorable to the regulator, and then the next day you send your invoice asking for a certain allowance, the person is human. He's going to look at you sideways and say, yesterday you ruled against me, today you are coming for payment. Maybe let me sit on it for a while. It can happen. And that is what will hamper the work of the tribunal.
Yeah, but when you took over, did you try to talk to the Justice Yeboah, who had just resigned?
Honorable Chair, I've always had a good relationship with Justice Yeboah, and because of his association with the University of Ghana School of Law, he always comes around, and we always have interactions. So picked one or two things, and that is one of the things that he actually asked me to look out for, because that specter of your respondent being your paymaster is a very unhappy situation.
Will you say that having stayed there for about 2 years, NCA with its dealings with the operators, especially the radio stations, sometimes have high-handedness?
With my experience, I won't call it high-handedness. You know, the complaints that keep coming in respect of what you will call high-handedness is in this context of a foul cry of they are the referee and they are also in the game. But that is how the law has made them. It is a regulator, it is in the game. So if you come to a tribunal and complain that they are the referee and they are also in the game, we only point out to you that that is the arrangement. Same as they are perpetual respondents and they are paymasters, we don't like it. So let's live with it. Maybe we should go down to the law and see how best we can clean these things up. But high-handedness, no, I have not encountered it. What we have seen, especially in respect of the radio stations, is that by the time we assumed office, we came in, the licenses had expired. And now the law does not grant my tribunal the power to issue licenses. If your license has not expired and you say the regulator is unfairly treating you, and so we should set things right, then we have the jurisdiction. If your license has expired and you're saying you are trying to get your license, but the regulator is putting stumbling blocks in your path, then we have the jurisdiction. But if your license has expired and you do not have any grounds, but you're just saying, I have been stopped from operating, and we ask, do you have a license to operate? And you do not have a license to operate. All we will tell you is that go back to the regulator, apply again for a license. If they don't put unnecessary stumbling blocks in your path, then you come for redress. And with that posture, all the radio station cases were resolved in just a few weeks because the appellants discontinued their appeals by the wisdom in that approach, and they went back to the regulator because we noticed that all the licenses of the appellants, the license of all the appellants had expired, which then robbed us of any jurisdiction. Because if you do not have a license, you cannot operate, and the tribunal cannot give you a license. It is the regulator that will give you the license. So you are in the wrong forum.
Chairman, just want to find out, I mean, there was this publication, and I think the video too is here, where after the death of Ahmed Swale, you made a comment with regards to Honorable Kennedy Agyebeng, and to just preface, said even your 4-year-old child will not speak this. I will not want to repeat the word you use. Do you remember that?
Yes, I do, Honorable Chair.
I know, having worked with Anas and the team, the pain that you went through, especially all of us, after we heard the gruesome murder of Ahmed Swale. You also said he should have apologized after the death. You said Honorable Kennedy Agyebeng should have apologized.
He should have apologized?
He should have apologized for exposing his picture.
Well, I don't remember the exact words, but the gravamen of what I was saying was that by putting out the young man's picture out there on television and calling for anyone who could see him to lay hands on him, he had exposed him in a way that was most unfortunate, and so he should own up to some responsibility. That was the gravamen of what I was saying. Because it appeared to me that, it appeared to me that had he not put the picture on TV, many people would not even have known of the young man to go after him. And so it exposed him more dangerously otherwise than it would have. And it is that context that I placed it, that the responsibility of putting his picture out there was clear.
And do you think that up to date he's been held responsible, at least for the part that he played?
I don't get the question.
I'm saying that, do you think the Honorable Kennedy Agyebeng has been held responsible for at least the part that he played?
Well, I have not seen any processes in respect of that, Honorable Chair. But I still keep to what I said there, that was exposing someone to a very dangerous situation. And you remember in 2018 when the number 12 expose came out, the reverberation was not just local, it was very international, all the way to FIFA, all the way to CAF, and there was a real shake-up. So you had all manner of, there were so many referees that have been banned and all that as a result of this expose. Not just in Ghana, in Kenya and other places too. So this young man who was the lead investigator, you may have people who may not want to see him alive. And to add to you putting his picture out there, that was a bit too much for my taste buds. And that is why I was calling the honorable member out that, look, that thing you did expose this young man to danger. And someone had identified him and taken him out very sadly, unfortunately.
And you think it's the same that is currently happening with Erastus?
I beg your pardon, who is Erastus?
Erastus Asari, the reporter for 2FM.
Kindly don't answer the question. The matter is sub judice.
Sorry, Mr. Chairman, sorry, it's before your committee. Sorry about that, Mr. Chairman. I'm just quoting you. Earlier you said this. You can't fight corruption solely on criminal law.
You cannot fight corruption solely through the criminal law, or solely by the criminal law.
You know the object of your office, or the office you hope to get there by the grace of God, if Parliament approves of you, that's Act 959. The third object, and I quote Mr. Chairman, says to take steps to prevent corruption. So far, in all this vetting, one thing that I've heard you say is about maybe annual publication of corruption index to show how agencies are doing when it comes to report on corruption and what have you. But you know that we need to do more than that to be able to make real headway. What, in specific terms, do you think we can do to help deal with these monies?
In terms of prevention of corruption, which is actually going to be, when given the nod, my main focus. If you take, for instance, the context of government agencies, we can strengthen the internal governance systems of all these agencies in order to plug it there. And that's why I keep referring to this idea of making corruption very costly and a high-risk venture. Because if the OSP is coming up with a risk assessment in respect of all the major activities that all the agencies are engaged in, if the internal processes have been established in respect of reporting systems, monitoring and evaluation and all that, if the internal audit systems of all these agencies are all cooperating with the OSP and the OSP has a keen eye there, then down there we will be blocking the crevices, we will be blocking the loopholes to make it tighter.
Chairman, I just want to find out whether he thinks his office may want to help or work together with SHRIDE and other agencies to develop a clear-cut gift policy.
Actually, you mean a reward scheme?
Gift policy, I mean, you see
Oh,
the way...
okay, I get it. I get it. Yes, indeed, I keep referring to it. Some time ago, I even gave a talk. I presented a paper to officers of SHRIDE who were being trained in bribery and all that, and I made reference to the gift to the gift giving specter that we face, and I have said countless times here that the way our society is structured is such that it is so difficult to distinguish the acceptable from the unacceptable in respect of gift giving. So, yes, we would have to come together. We would come together to develop that policy, and that is an integrity plan, an integrity check.
The majority there was here telling me why you keep shifting the goalposts. I mean, let's admit our primaries as parliamentarians, our political parties in the campaign for the presidency and parliamentary, the way everybody is on us, and virtually it has now become a norm. If we don't really work on this, I don't see how even Parliament will have the courage, because virtually you are just dishing out. The chairman and I will tell you in Pan-Africa, I think Zambia, a member of Parliament was deposed from his position for simply giving 50 bags of cement to a church, because they thought that that was something that was baiting. And I said, in our country, this is this is a cream that we rob
it's a ritual
every day. But the challenge is that they have a clear-cut policy that says that you cannot do more than, say, maybe 30 bags, and he did 50, and that became a problem. Around this table, people donate 1,000 bags and what have you easily. Primaries, see the kind of things that people share. People put money on the table in the broad daylight.
And which are these disclosures that I should be mindful of?
Unfortunately, I have not mentioned anybody's name. But it is glaring. You see the videos going around. You see the videos going around. You see in primaries, televisions, TVs, televisions, fridges, cookers. I mean, if we don't really come out with this policy, we'll virtually be collapsing our democracy.
Oh, no, I couldn't agree with you. I couldn't agree with you more.
And I really, yes, you see, that's the challenge. You see, it's reminding me that the delegates are listening to me. And lastly, Mr. Chairman, I know this is a very difficult one, and I don't expect a special prosecutor to be able to really change that much, except maybe in policy formulation and his effort to engage other agencies, the religious leaders, we all will begin to truly talk about this, our attitude. If we don't get the attitude changed, people sometimes think that a member of parliament is coming from the space, or the president is coming from some different heavens. It's all among us. So our attitude is something that we need to change. I wish you well, and I pray that you become successful in the office. Thank you very much, Mr. Chairman.
Thank you very much, Honorable Chair.
Chairman, do I have your indulgence to proceed once again to note that we are being assured by Kissi Agyebeng. But Chairman, corruption is said is legally wrong, morally wrong, economically indecent. When the office of the Special Prosecutor was announced, subsequent to it, a bill was placed before Parliament. My understanding is for the President to have expressed faith in a neutral, independent Special Prosecutor beyond the Attorney General. Now hear these words, and I just want your reaction or assurances to it. The Embassy of the United States of America wrote to then Committee on Constitutional, Legal, and Parliamentary Affairs. And Chairman, these were their words. Our foremost recommendation is that the office of the Special Prosecutor be seen to be free of political influence and interference. Will you be free from political influence and interference? Your leg is not you, it's probably the president who has failed in that bit. That's not you, but I'm being fair to you. It says, specifically, the appointment of the Special Prosecutor should be subject to a transparent, competitive shortlisting process. So maybe we have failed in that enterprise. I'm not aware that there's been any public advertisement inviting desirous or qualified persons to that office. But as I said, it's the appointing of authority. So the president next time must respect that process. But for your purposes, you are here. But that was the observation of the U.S. Embassy. And he added what we are currently doing, ample scrutiny by Parliament. So I appreciate the fact that we are scrutinizing you. And then what role civil society plays. Now, having listened to you with the Honorable Muntaka, when your appointment was announced, the Honorable Kennedy Agyebeng had some uncharitable words for you. Do you think that it was just payback because of the courageous position you took in respect of Ahmed Swale, or we should believe the things that he said about you? Thank you, Chair.
Honorable Chair, I never heard what he supposedly said.
Will you be interested in hearing them?
I don't dwell on those things, Honorable Chair. Yeah.
In summary, you were not fit for the office of Special Prosecutor, unquote. What would be your reaction to that?
That is absolutely wrong, Honorable Chair.
So it should be ignored?
Totally.
All right, Chairman, that brings me to, what's your position on review of asset declaration regimes? It appears that it's just not working for Ghana. You declare assets, you file them before Auditor General until there is an investigation by judicial or quasi-judicial bodies. Nobody knows what is going on. Public officers earn income not commensurate to our earnings. We give legitimacy to it even when it is not lawful. What would be your position? Do you subscribe to a review of Ghana's asset declaration regime? Thank
Honorable
you,
Chair, I do absolutely subscribe to that. And that will dovetail into what the Honorable Muntaka
What would be your proposal? If you want a revised or a new asset declaration regime, what should the Ghanaian public expect from you in order to deepen public officer accountability in our country? Thank you, Chair.
It will fit in the much earlier answer I gave in respect to a question that you asked. are you reasonably able to explain this wealth, its source, as matched against your lawful income? That is what the standard that we should apply. And with that, and our attitude of filing these returns, enforcing the filing of these returns should lead to a progressive outcome in this contest. Because then if you're unable to explain how you came about this wealth and the source is concealed, the source is shady, the source is converted, then clearly you would have questions to answer.
Thank you, Chairman. Chairman, I'm holding here fair to the nominee. He would not, since he's not member of parliament, report of the Auditor General on the public accounts of Ghana ministries, departments, and other agencies, MDAs, for the financial year 31st December 2019. And as Special Prosecutor, assuming you just had a cursory reading of any of the Auditor General report tied to Section 3 of your act, which gives you your mandate, and it reads, tax irregularities, 2,666,000,000. It says cash irregularities, 276,624,000. It reads further contract irregularities, that is 77,000, still state money. And then payroll irregularities, 469,953. Outstanding debt, 201,000. You just read this, and you are a Special Prosecutor. What will ring in your mind, and what would you want to do to protect the Ghanaian public purse with these continuous abuses? Thank you, Chair.
What rings in my mind is that if it means that I have my job clearly cut out for me, that it is an uphill task. Once again, I'm not naive to assume that it is going to be a stroll in the park. And I would recall what I said earlier in terms of the innovations that I'm going to bring on board to ensure that the office is methodically run with deliberation to achieve the objects under Section 2 as married with the functions under Section 3.
Chairman, the nominee responding to a question posed by the Honorable Muntaka, he was driving you towards conflict of interest. You want your law chamber to run. You have worked on LNG and contract and GMPC. Assuming the matter of LNG or GMPC's involvement in LNG tomorrow becomes a matter for an investigation that borders on abuse of office, what will you do?
You see, in that regard, Honorable Chair, we acted as lawyers. We have given our advice in respect of the transaction, and we've pulled out. That ends our involvement in respect of that.
Assuming that part of your advice which led to the initiation, which results in the involvement of a state entity of GMPC involved, is now a matter that is being questioned by your office. Will you
Honorable Chair, that is what I was aiming at, that a lawyer's advice is a legal advice. And it is not an invitation for anyone to engage in corrupt acts or corrupt practices. That is what
this will never be known to you. And Chairman, I hope I can elaborate this. To quote your words, as you answer the question, I believe posed by the Honorable member who chose to be saying everything about you is law, law, law. Your answer was that it is secretive and complex. That's the nature of corruption. It will continue to be so. Corruption is the only criminal act, particularly when it borders on bribery, that both the giver and the receiver are rewarded and compensated. That's why gathering evidence becomes difficult, because the person will not hang himself because he himself gave it out. I'll read something somewhere in order to be able to benefit from a bureaucratic process. So given that it's secretive, it's complex, give us an assurance. Every other person from 1979 through 81, military interventions in Ghana, corruption was cited as a bane. Even yesterday, it is still a bane. What will be the Agyebeng mark Thank you, Chair.
This Honorable Chair, I believe I have stated it more than once, that I'm going to approach all cases with the same object, ruthlessness. And that is my mark.
Even cases that involves your friends and family members?
Yes, I have to.
Your very close friends that we know?
I would have to.
We should expect that of you, an assurance given by you.
Yes,
I want an assurance from you.
Yes, I'm giving that assurance. What I meant by what I said earlier is that I am going to approach every case, every specific allegation of corruption-related offenses with the same object.
Yeah, I've been researching further on it, and I'm quoting from Liu, 1985, Huntington, 1968, and the argument that corruption serves as an incentive payment to remove government-imposed inefficient rules. You have a duty to prevent corruption. The bureaucracy of Ghana has just created a situation where the inefficient rules allows for it as a facilitator. What will you do to combat?
By rules, do you mean enactments?
Whatever interpretation you give to it, even getting the bureaucracy speed up.
The reason why I ask Honorable Chair is that if they are just rules by way of convention, then those are easily tackled down with the operation of the law. Those
Chairman, I want the nominees take the exploitation of Ghana's natural mineral resources have been cited heavily as one major area where corruption is prevalent. In addition to the fact that that is why the EITI, the transparency required of it was done, as going to the high office of Special Prosecutor, what assurance do you have for the country Ghana in terms of protecting the abuse and fraud associated with our natural mineral resources, and what will you do? Thank you, Chair.
Once again, it would have to be repetitive. In terms of all the things I've stated earlier in respect of what I'm bringing on board and my innovations, they are not different from other forms of corruption. They are going to be tackled in the same manner.
Are you assuring me that you are not just going to come and your focus will be on public office holders? I saw you read portions of your art, which included the Ghanaian private sector. And Chairman, as I indicated, natural resource management, this is the observation that have been made with the state in Ghana. Corruption is not uncommon when dealing with the natural resources sector in Ghana. GAN Integrated 2018, and they say that local elites, limited transparency and accountability leads to funding misuse and embezzlement in community-based natural resource management in Ghana. What will you do about that?
Honorable Chair, as I cited a long act of Act 959, it is not just in relation to public officers. It goes also to politically exposed persons and to persons in the private sector. And Honorable Chair, I'm also going to look closely at the activities of foreigners and foreign actors in this country. The reason why I say so is this. It appears to me that although we have laws regulating our activities, when it comes to the enforcement of laws in relation to foreign persons, we appear to turn a blind eye to some of their activities. The law that will apply to, say, a Ghanaian businessman and squarely fix him with some legal liability will not necessarily apply to a foreigner, from my experience. And so, it also extends there to the activities of foreign nationals and foreign actors in the country. With my coming in, if given the nod, that practice stops. It ends.
Chairman, I'm wearing a white, beautiful smock. Chairman, yesterday I went to Yendi, and the Yana gifted me this smock. Gift. I accepted it in good faith. I was in the company of the Honorable Sohine. Now, in your answer to an earlier question, and Obasanjo, then when he was working on corruption, and I'm going to give just to get your thinking on some matter. Obasanjo said that what distinguishes a gift in the true cultural sense, Ghanaian, from a gift that is meant to corrupt, is that yesterday my gift was in the open. First requirement, in the open. The gift must be in the open. He added that the gift in the cultural sense must also be a token with no intention to corrupt. Now you are in Ghana. December, you see pickups of government vehicles carrying a ponchi, pademawe chama is goat, goat, yam, guinea fowl. The assumption is that that is from the public purse or associated with the public purse. We take it lightly and for granted, but that is bleeding the Ghanaian public purse. And public officials accept it with joy and alacrity. Probably, if you want, we accept it with alacrity. Kissi Agyebeng, Special Prosecutor, what will you do about this Ghanaian cultural norm that exceeds the tokenism of a gift and the openness of a gift? I thank you, Chairman.
Incidentally, Honorable Chair, the Criminal Offences Act has some provisions in respect to the openness or otherwise of gifts. So in respect of a public function, for instance, the clear idea is that if you are receiving it after the performance of your function, for instance, and it is not in the open, as you rightly put it, then it will be presumed that you were corrupted before you perform the function. That is to say, you should receive it in the open. But this will then go back to your prior suggestion, which I agree with you, that we need a policy, a clear policy on acceptable gift giving and unacceptable gift giving, because it is a very hazy proposition as it stands now.
So, Kissi Agyebeng, assuming there is an allegation against the president, vice president, or the speaker, as it appears in respect of the speaker, you had announced principle of $40,000. Will you have the courage to investigate it?
Yes, Honorable Chair, I will, and that is why I accepted the nomination in the first place.
You will serve this high office without fear or favor? Is that your assurance to this committee?
I've had a long thought process in respect of this position.
And not abandon investigation along the line because there's interference from the political elite of our country?
Honorable Chair, I would have to steer the course. Otherwise, I have no business being in the position.
So, vexed relationship, you referred to it again when you are answering a question. Money laundering, the relationship between your office, Bank of Ghana, all the money flying out in Ghana, Ghanaians who a few years ago could not afford or have properties in London, Mayfair, Knightsbridge, have them, and associated with politically exposed persons as public officials. Will you, Kissi Agyebeng, have the courage to investigate those matters if they are brought to your attention?
Once again, the principle I enunciated stands. If you are unable to reasonably explain...
And you share the view that that probably have been acquired from wealth that cannot be explained. Will you do that?
Honorable Chair, that's what I was on. That's the principle I enunciated stands. That if you are unable to reasonably explain as matched against your lawful income, you would have questions to answer to me if given the nod.
Now, this is not for your answer. I'm sure the whip reads it because Parliament is here. The leadership is here. Deputy Speaker, who chairs this committee, represents Parliament. As for that house cleaning, it's not your work. It's for Parliament to clean itself of how they get elected and how they get to sit on this committee. But probably, you know that under the electoral laws of Ghana, what the Honorable Muntaka was referring to is unlawful. Are you aware?
Yes, Honorable Chair.
Will you exercise the gavel as Special Prosecutor that this is indeed unlawful?
There are provisions in Act 29 in respect of electoral breaches. So, and
haven't perused the Special Prosecutor Act.
And they come directly under
with the exception of the subsection dealing with clause 4 and its subsections. Which other aspect of the legislation do you find a candidate for review or reforms?
The definition of corruption and corruption-related offences. They're spelled out there. And these election infractions come under the purview of the office.
If a minister awards a contract to the girlfriend, that's abuse of office or a member of, and you get to know, what will you do?
Same principle, Honorable Chair.
State the principle now.
The principle is I'm going to look at every matter in the same way. Ruthlessness.
The Agyebeng principle
is
as
ruthlessness.
Extended. Chairman, thank you very much. I'm done.
Okay. I'll ask you a few questions. One of the articles you stated as having published, as a seminal paper on your CV, is Corruption and the Law. Sometime in 2007 or thereabout.
And that was a presentation, not a published paper, Honorable Chair.
Very well. I've had the opportunity to read it very carefully.
I'm most honored.
And I think it's very exhaustive in terms of covering all the laws relating to corruption. So you appear to have a bird's eye view of all the laws relating to corruption. But your conclusion is very interesting, and for me, that's what interests me. However, it is the implementation of the provisions in the sense of the willingness to prosecute offenders and the interpretation put on the provisions by the judges that will become most instructive. In my view, it sums up the real challenge you have as a special prosecutor. The integrity deficit in our country. Honorable Muntaka calls it attitudes. I call it the culture of dishonesty in our country. It's a culture. Even young people will lie about things just right around you. I'm saying your biggest challenge is how to first, even the officers you work with. In the end, you're the head. You send people on the field. You will rely on the report they will bring you. Whether or not the true reflection of the facts is a matter you have to deal with. Whether or not people will give you the true information is a matter you have to deal with. But how do you think we can deal with this canker, this culture of dishonesty, which, in my view, is engulfing us?
I'll borrow from the Honorable Buntaka's words again. Our attitude, as the first thing. Because being appointed as a special prosecutor doesn't overnight make me carry a magic wand to quell all forms of corrupt practices. Without the cooperation of these agencies, for instance, as the Act itself spells out, without the cooperation of this House, the Act actually also says that this House can refer matters to the OSP for investigation and action. Without the cooperation of all of us, I will not be able to achieve much. So on this score, Honorable Chair, I will call on all of us, all Ghanaians. If we are tired of corruption, yes, we are tired of corruption. I need everyone's help. I will need everyone's input. Let's change our attitudes and let's fight this fight together. I cannot do it alone. I'm just but one person. I will need everyone on board.
That is your real challenge, and in my view, because everyone, I tell you, you'll find that everyone is not tide of corruption as you suggest.
That is why we have laws here. It envisages that some will still, no matter how costly it is, some will still engage in it.
Well, somebody wrote an article that Ghanaians don't abhor corruption. And if you happen to be in a position of giving goodies, you will know that everybody thinks that he deserves it without going through the normal process. Who doesn't? If he doesn't get it, then he'll complain about the other person. That is the real Ghanaian attitude. I think that probably we should look at training young people afresh. I suggest that to you, that is a policy you should want to investigate, that probably we should start training new people with new values at the very beginning. Hopefully by the time they turn 20, 50. Somebody said that who would train them? I was discussing this with somebody and said, oh, what we really need to do is to go digital. Prepare the things we think can change people's, form new values on electronically and send them to young people. They have, a lot of them have access to electronic gadgets, and probably we can turn things around. I mean, this is just my suggestion to you. On that note, thank you for attending upon the House to answer questions. You're discharged.
Thank you so much, Honorable Chair. Well, before leaving, if I may acknowledge, Kwauman is here representing the Kwauhine in the person of the Marehine of the Kwau State, and then the Adonzine of Impraiso.
You see, we have stopped acknowledging that. But like you said, I saw an MP striving and maneuvering. That is what we mean by as soon as we stop something, somebody wants to return to it.
Honorable Chair, pardon me, this is my first time here.
And be warned that you're not guilty of corruption of the process before you start.
Thank you very much. It has been an honor.
Thank you. You are discharged now.
Thank you.
The president and the prime minister. No.
Hello, kindly excuse us. We want to complete our processes. Thank you. Media, can you excuse us now? Thank you very much.